Good afternoon and welcome to the Appellate Division First Department. Nice to see everybody today. I will tell you that we have almost 7.5 hours of oral argument requested. So I think that's going to be a little unrealistic. So we have to ask you to please just request the time that you really need. Remember that we've had the briefs and the records and we are very familiar with your cases. If we have questions after the time runs out, we will ask them. The red light is for you. You're supposed to stop when the red light goes on. I say that because so many people don't. And when the white light goes on, that means you have 2 more minutes. So I'm going to start with the call of the calendar. The first case on the calendar, People versus David Carter. Okay, 6 and 2 and 6. Twersky versus Yeshiva University. Okay, submitted. Holland versus Theon. Okay, both of those cases will be submitted. People versus Clarence Thigpen.
Appellant request 6 and 2, Your Honor. Respondent request 5, Your Honor.
Okay, thank you very much. 6 and 2 and 5. Wallson 316 versus 316 Bowery Realty. So I believe we have 2 appellants here. We have plaintiff.
Plaintiff appellant request 7 and 3.
Bleeker.
And Bleeker request 7 and 3 as well.
And respondent.
316 Bowery request 5.
Okay, I'm going to give you 5 and 2, 5 and 2 and 5. If we have additional questions, we will ask them. Thank you. 79 West 12th versus Kornblum. You request what? 12? Okay, 6 and 2 and 5. People versus Kevin Avila. Submitted. People versus Gregory Fleming. Okay, thank you. 4 and 1 and 5. Dai Chai Life versus Aubrey Corp.
Appellant request 6 and 2, Your Honor. Respondent request 5, Your Honor.
Okay, thank you. 6 and 2 and 5. McPherson versus City of New York. Appellant? You don't see the appellant? Okay, so do you want to submit or? I'm sorry? Does anyone have any questions? I don't think we do, so if you're comfortable, we can mark it submitted. Okay, thank you, Thank you, counsel. People versus Mario Tingling. Okay, 5 and 2 and 5. Tian versus Apollo Management.
Appellant request 6 and 2, please.
Respondent request 5.
Okay, 6 and 2 and 5. Stop Irresponsible Frick Development versus New York City Board of Standards.
Appellant request 6 and 3.
Okay, and then we have both Frick, who represents Frick? And Board of Standards? Okay, 6 and 3, 5 and 5. Thank you. Elberg versus Crabapple.
Appellant request 12 and 3, Your Honor. Respondent 8.
I'm going to give you 5 and 2 and 5. Thank you. People versus Bernardo Sanchez. Submitted. People versus Kirby Velez. Okay, 5 and 1 and 5, thank you. Jewish Press versus Kingsborough Community. Okay, thank you. And last, ALP versus Moskowitz. I know we have 3 appellants here, so I don't know if you've discussed this. Who's going to go first? Okay, and the Frank people, the accountants? Okay, and Park West?
5 and 2, Your Honor.
And where's the respondent? Okay, I think that's fair. So 5 and 2, 4 and 1, 5 and 2, and 8. Okay, thank you very much. We'll start with the first case for argument, People versus David Carter. Okay, good afternoon. You may proceed.
Good afternoon. Emma Schriefter from the Office of the Appellate Defender on behalf of Mr. David Carter. The court's handling of the first jury note is a clear violation of the mandates set out in ORAMA and Criminal Procedure Law 3-1030.
Well, I have to admit it was kind of an odd-looking jury note, and it seems that the judge almost verbatim tried to read what the note said to the lawyer. So what was such a flagrant violation of ORAMA?
Well, there were several errors here, but I would say the most significant was that the judge did not inform defense counsel that the jury was asking for all of the elements of weapons possession.
Counsel, is it your position that defense counsel did not see the note?
Correct.
Which was really a rhetorical question. Couldn't we infer from this record that in fact counsel did see the note? Certainly didn't ask for a clarification or anything like that, right?
Well, first, this court cannot presume that there was any...
Well, I'm not presuming. I'm just asking you, is it a fair inference to draw?
No, and I would point the court to page 220, where the prosecutor mentions reviewing the transcript from the prior day, but not reviewing the note. So there's nothing here on the record that would indicate that any of the parties ever saw the note.
Well, is there any indication that counsel on the record said, I'd like to see the note? Or anything like that?
Well, there's no need for objection.
So if it's not there, couldn't we infer from that statement, in fact, that the note was seen?
No, this court cannot make that inference, and defense counsel didn't need to object. Defense counsel wouldn't know that there was something to object to. He wouldn't know that there was something the court wasn't reading. And even so, that he would have known that there were errors. Had he known that, he would have made different requests. And the significant errors here were that the court made alterations, additions, and omissions of part of the notes. And that significantly altered the meaning of the requests here. And respondents suggest...
Well, but how do you interpret what the jury was asking for? Weren't they asking for issues with respect to intent?
Sorry, I didn't hear that.
What do you believe the jury was asking for in the note? As my colleague points out, has arrows going in different directions. What do you think the jury was asking for?
Well, as to the first line, weapons possession, intention, arrow, general, question mark, I would assume that means whether the intent of the weapons possession definition is general. But the judge changed the arrow into the word versus, which alters the meaning. But I do want to point out here that the question is not what the note said, Or rather, the question is not what could have been said. There's no prejudice analysis here. This court cannot look into what counsel may have said or should have said in response to this note, but instead whether the court read it verbatim. And by altering again, the arrow into the word versus, that changed the meaning. And she also admitted that there
Counsel, I'm sorry to interrupt, but did the juror's interjection, which was unusual, did that clarify matters?
No, first of all, the juror said we want the specificity of intent. And that's not what the note said. The note says intent general, question mark, specific question mark. So if anything, the juror's question made it even more confusing. And also, there can't be the rule that it's the jury's obligation to inform defense counsel of what the note says. That's clearly the court's obligation. And again, this court can't look into the prejudice of what the outcome could have been if the note was read verbatim.
So the court gives a supplemental charge on intent, right?
Yes.
And defense counsel doesn't object, correct?
No.
So what's the implication of that?
There is no need for objection. Defense counsel would not know from the reading of this note that there was an error in the reading, and that's exactly why ORAMA doesn't require objection. There's no clear, then this court cannot presume that there would have been any other suggestion made by defense counsel, and which is exactly why the note must be read verbatim.
Do you want to discuss at all the dangerous instrument argument for 40 seconds before your time is up?
Yes, I'll just quickly say that there was no evidence here that Mr. Carter was suggesting that he was going to actually harm Mr. Feibusch. Mr. Feibusch clearly said that Mr. Carter pointed the dangerous instrument at him and showed him the bottle opener, and that is not a threat.
Well, I mean, if you saw that, and I know you did, saw the picture of the bottle opener, there's a metal tip at the end of it, which certainly could be used to injure someone.
Right, it may have been able to be used, but in this context, there was no indication that Mr. Carter was going to use it in that manner. So for all those reasons, I request that the court reverse and dismiss, or at the very least, reduce Mr. Carter's sentence to the minimum of 10 years.
Okay, you'll have 2 minutes for rebuttal, okay? Thank you very much.
Good afternoon, and may it please the court, Stephen Kress on behalf of the people. The trial judge in this case read the jury note to the jury, and I think that's clear if you look at—
But what about your adversary's point? I mean, the arrow was mishandled.
I'm sorry,
The arrow was mishandled as to the interpretation of what the arrow meant.
Well, she originally misspoke. That's correct. She says intent versus general. That was a misstatement. But immediately right after that, she says, it has an arrow to general. And so I think that shows that she's looking at the note. She's reading directly from it. And she clarified what she had just misspoken about just a moment earlier. And again, at that point, there's no comment from defense counsel about saying that he's confused or he doesn't understand what the substance of the note was. And to the extent that there was any confusion or ambiguity at all about what the contents of the note were, the jury resolved that. When a juror spoke up and said, actually, Your Honor, we had a question about the specificity of the intent. At that point, defense counsel knows what was in the note, if he didn't already know before that. And to your point, Justice Singh, I think it is fair to infer from this record that the note was shown to the parties, although I don't think you even necessarily have to get there, because I think the judge read it into the record.
And you're basing that logical to infer that on what?
Logical to infer that it was shown to them?
Yes.
So I think if you look at pages 20 to 21 of our brief, after the judge comes on the record and reads the note, the parties start talking about how to respond to it, and defense counsel makes a reference to the parties having already started looking at the charges on his phone. He says, oh yeah, we've already been looking at this on our phone. And that's only part of it. I think you could also support that inference from the way that other notes were handled in the record. The second one, for example, when the judge starts talking about it on the record, she's almost starting kind of midstream, as if the parties already know what had been written in that note. And even with respect to this first note as well, the first thing that the judge talks about were the requests for exhibits. And she says, okay, so they want, this exhibit calling for this material. We've already sent that in, right? And the answer is yes. So I think all of that supports an inference that it had been shown to the parties before off the record. But as I said, even notwithstanding, it was read into the record. And then when the juror spoke, I think that certainly resolved any ambiguity. And at that point, counsel was in the same position that the defense counsel was in People v. Nealon, which is a case we cite in our brief, where he has full understanding of what the contents of the note were, and if he had any comments about how it should be handled, it was his obligation to speak up at that point. I will briefly address also the dangerous instrument point, only to say that the victim's subjective reaction to being threatened with an object should not determine whether or not that is a dangerous instrument. I know defense counsel made an argument in their brief about how Dr. Freibush's, reaction to him following the defendant and pursuing him, trying to get his phone back, suggests that he wasn't threatened with a dangerous instrument. That's just not the case. And I'll refer to the court to People v. Espada, a case we cite in our brief where a store employee was threatened with what this court concluded was a dangerous instrument, even though after being threatened, he then chased after the defendant in that case.
So is it the showing of the bottle opener with the phone in hand? Is that suggest that the defendant intended to, was threatening some kind of harm and intended to retain the phone?
Yes, Your Honor. Well, I think it's not just showing it, it's the fact that he's pointing it at the victim. I think that is a threat to use it in a way that could cause serious physical injury. I mean, most notably, slashing somebody in the face. So yeah, I think that would be enough, and it's different from the cases that defendant cites where a gun was pointed at somebody, an unloaded, inoperable gun. Pointing an unloaded, inoperable gun suggests you're going to shoot the person, and if it's unloaded and inoperable, that can't cause an injury. But certainly pointing a sharp object at somebody would be, that is indicating that you could use it in a manner that would cause serious physical injury. And if there are no further questions, I would just ask that the judgment be affirmed. Thank you.
Thank you. You have 2 minutes.
Yes, I first want to address the issue about counsel should have noted his concern or raised an objection. If we look to the Court of Appeals case, People versus Parker, the court specifically said, I will read the note when the jury's here. And defense counsel didn't make an objection, and there is still a motive proceedings error in that case. And also in People versus Martin, the judge read the note later to the jury, but never to defense counsel. And again, that was a motive proceedings error. And the same should be found here. Second, the court did not fix her error by saying there's an arrow to general. If anything, that added to the problem because then it made it sound like there was the word versus as well as the arrow. And she didn't clarify that there was the arrow instead of the word versus. So this was not a correction of her error. Again, this court cannot infer anything in terms of the conversations of whether the parties indeed had the note. It would have been...
Can we infer that at least meaningful notice of the contents of the note were given to defense counsel?
No, it's not meaningful notice when the when the court made several errors, alterations,
Well,
omissions.
several, but really you're talking about one, right? Versus the use of the arrow?
Well, there's the other significant error where there's on the side of the note says elements in each crime. And she said robbery versus grand larceny. I think elements of each crime, which means she never indicated that the jury was also asking for the elements of weapons possession. And it's clear that when defense counsel is not made aware of requests for definitions of elements, that is a mode of proceedings error. So again, I ask that this court please reverse and dismiss, or in the alternative, reduce Mr. Carter's sentence.
Thank you.
Thank
Thank you
you.
both. Next case for argument is People versus Thigpen. Good afternoon.
Good afternoon, Your Honors. May it please the Court, David Bernstein on behalf of Clarence Thigpen. The prosecution's 3-year delay in presenting this case to a grand jury violated Mr. Thigpen's due process rights. And I'd like to begin by talking about what is not disputed here. There is
Oh, I mean, it was still within the statute of limitations, and Mr. Thigpen had fled or absconded shortly after this incident, and the police apparently had no address to reach him at. So what makes this so unreasonable and violating his rights?
Well, a few things. First of all, Mr. Thigpen did not flee the state, and that I have to be absolutely clear.
He didn't go to North Carolina?
I beg your pardon?
He didn't go to North Carolina?
Mr. Thigpen was arrested in Columbia County, New York, and
Sir,
extradited
excuse
to
me,
North Carolina.
answer my question. After the incident, what did your client do?
There is no evidence in this record whatsoever that he ever left New York after this incident.
So it's your position that
There's zero evidence in the record.
it's your position that he was always in New York?
After the incident in this case,
That's right.
until he was extradited to North Carolina, that is absolutely clear on this record.
Okay, fair enough.
The only evidence about him being in North Carolina predates this incident, is 6 months earlier, May 2012. So there is nothing in this record that suggests that he left New York after this incident until he was extradited to North Carolina involuntarily in August of 2013. And in fact, he had been arrested upstate New York in April of 2013 and was held in custody in New York for 4 months. So the police.
So you're saying when he then was returned to North Carolina after that, what you're saying is he was returned on a warrant for something that happened before this incident? Is that what you're?
That is absolutely
the-
correct, Judge. It was a warrant issued prior to this incident because of conduct that happened in North Carolina prior to this incident, and he was arrested in New York and extradited involuntarily to North Carolina. So I do want to be very clear about that. There's nothing to suggest he left New York.
He was arrested in Columbia County, New York.
Correct.
Okay.
And I think it's important to note that there had been an I-card lodged by Detective Costello, and presumably that I-card would have hit when Mr. Thigpen was arrested in New York, and then Mr. Thigpen sat in New York in Columbia County for 4 months before he was extradited. So the prosecution had 4 months to go get him in Columbia County or bring him back here.
But is there any evidence that they knew a last known address to be able to locate him? Certainly the person he was with before didn't know where he was, right?
Well, I think two things. I mean, first of all, I think Detective Costello closed the investigation on this very quickly. There were basically 3 days, on the record we have here, there was 3 days of police investigation. He then filed the I-card and did nothing else other than talk to a warrant squad detective and say, there is this I-card. So there is some indication in the record that he made some effort But we have no facts to support what that was. And I just want to note that in response to the speedy trial motion, the prosecutor had every opportunity to offer evidence explaining what steps Detective Costello took. They didn't do so. And I think that's the core of our argument here, is that the only things we have in this record, and again, this is a narrow case, other cases, the prosecution may present ample evidence of their steps. In this case, the only evidence we have is that the police closed their investigation 2 months after this incident and then did nothing for 3 years.
Okay, let's assume for argument's sake, you're right on that point. So can you tell me how was there prejudice as a result of the delay?
Sure. So the prejudice here flows directly from the police's lack of investigation. And in particular, I want to point out.
I'm sorry to interrupt you. I apologize, but am I not correct in my understanding that, in fact, the NYPD was alerted of defendant's location in December 2013, which was about a year after this incident? So they did do something. They tried to contact the complainant, but they had a problem getting her to testify. So to say they did nothing for 3 years is not really accurate?
Well, it wasn't actually, the police notified the prosecutor, all they did was notify the prosecution, and at that point, the prosecutor reached out to the complainant for the first time. And I think that's really important, is that the prosecutor actually only made that single attempt to try and contact the complainant. This goes into the answer to your question, Justice Singh, which is that they made one attempt to talk to the complainant, and after that, nothing happened for 2 more years. And the way that it prejudiced Mr. Thigpen is because by the time they decided to actually kickstart this investigation again in 2015, the 911 call, which suggested from the Sprint report that Mr. Thigpen had been chased by Ms. Robinson, was destroyed. The witness who had called 911 was unavailable and not located. And so Mr. Thigpen's ability to prepare a defense was impeded because...
So in other words, your defense to the domestic violence would be that she was chasing him and he was defending himself? I mean, that's...
Well,
that's
first of all, I mean, may I finish?
Go ahead.
Yes. Go ahead.
A justification defense is entirely valid. First of all, I think there's questions as to whether this was actually a domestic violence case, because Ms. Robinson apparently did not have an address for Mr. Thigpen. But even setting that aside, a justification defense, this would have been a he said, she said trial. And any evidence that could have corroborated Mr. Thigpen's side of what happened flowed from that Sprint report and that 911 call, which were destroyed as a result of the delay in this case.
Am I wrong that the defendants allegedly stabbed the girlfriend 4 times? I mean,
all we have is the allegation
is
in the
that a
indictment.
he said, she said?
All we have in the indictment is the allegation of that.
Okay, you'll have 2 minutes for rebuttal. Thank you very much, Counselor.
Good afternoon, pardon me. Good afternoon, Your Honors, Counsel, and may it please the Court. My name is Reva Grace Phillips, and I'm here today on behalf of the respondent, the Bronx County District Attorney's Office. The 5-factor Taranovich balancing test guides our conversation today, and it clearly guides us to a finding that defendant's due process rights were not violated by a 3-year delay from the day that he viciously and repeatedly stabbed his ex-girlfriend in broad daylight on a Bronx street to the day he was arrested. While we acknowledge that one of the Taranovich factors weighs strongly in neither party's direction, the remaining 4 clearly weigh in the people's. As such, we seek an affirmance. And I'll dive right into the clarification around flight. While I think that's a relatively minor component to our argument and shouldn't be determinative, I understand that there's some lack of clarity, so I want to provide that to the court up front. We're alleging that defendant fled right after the incident occurred. He ultimately came back to New York and was arrested. We find record support there in 2 places. One, the underlying court's decision in order directly states that defendant absconded to North Carolina before he returned to New York.
I don't know if that's evidence. I see she said that, but...
Yes, Your Honor, and I would just say that as we always know, the trial court is in the best position to understand what's happening with the case, so I think there is some...
So what other evidence other than what the judge said?
Absolutely, moving right on. The second thing I'd point to here is defendant actually provided the the speeding ticket that he got in Columbia County. And if you look at that ticket, he gave a license that said that his address was Washington, North Carolina. The officer, and nowhere on that ticket does the officer note, oh, he says he lives up here now, oh, he's going to change his license. As your honors are well aware, New York requires you to change your license within 30 days of residency. So at least as of April 2013, he was holding out to law enforcement that he was domiciled in North Carolina. So I think that's some record support for the fact that this defendant absconded and then returned. Your honors, I note the length of delay here was not that substantial. This is the factor I think weighs strongly on neither party's side. Courts have upheld much longer delays.
I'm sorry, can you respond specifically to the prejudice that your adversary has pointed out with respect to the unavailability of the tapes?
Absolutely, Your Honor. So first, I think that the people more clearly articulated the prejudice that accrued to us. I think courts handling this issue have repeatedly noted that often the people are harmed more by a delay than defendant is. We articulated clear prejudice. The 911 caller was gone, but also EMS workers forgot the details of their response to this incident. A responding officer had retired by the time we wanted to move forward, and an eyewitness had moved. But going more specifically to the two primary contentions defendant raises, the loss of the 911 call and his inability to find new witnesses. Your Honor, he's just told you that he had the Sprint report. He had a Sprint report that was duplicative.
Was there any indication that there were, in fact, any witnesses on any police report or anything? Was there any indication?
So, Your Honor, obviously there was a 911 caller who
Right.
witnessed the crime, but that's exactly what I'm saying. There was a Sprint report that was duplicative of the contents of that call. And the second thing I'd point out is if you look at the plea minutes at page 3, you'll see that the actual context in which defendant ultimately decided to plead guilty was the court said, you're going to trial, it's happening, this is your exposure, and the people have found new witnesses. The people have found prompt outcry witnesses, and they have found an eyewitness. So, Your Honor, it is specifically in the context of hearing that the people actually found witnesses, actually went out and did that work, and came back with witnesses, that this defendant suddenly said, I need to go talk to my lawyer in the back, and then came back into the courtroom and pled guilty. Your Honors, I think there can be no doubt that two of the factors are in our favor. That's the underlying charges here, which the lower court correctly noted were very serious violent felonies. Pretrial incarceration. Here, defendant was not incarcerated at all pre-indictment. The reason for the delay, I think, is clear here. The officer, I'll contradict my opponent's argument here. The officer did take a lot of steps. And this is that exact period where we're alleging that defendant fled the state or fled the jurisdiction. The officer not only requested the assistance of another detective in his investigation, he searched an NYPD database. He issued that I-card alerting the entire NYPD to defendant's wanted status. He reached out to the defendant's parole officer. He also had the NYPD warrant squad conduct an entirely separate investigation. None of these attempts over the place of 2 months ultimately resulted in defendant being found, but even when an officer closes an investigation, the I-card remains. Clearly, there is some human error involved in this process where that I-card did not pop. And I would point, pardon me, that's colloquial slang for the I-card did not hit when he was arrested in Columbia County. But Your Honors, I would point to the clear evidence of good faith. When the prosecutor could move forward, he did. When the officer knew where defendant was, he let us know. The minute the officer becomes aware that defendant's on probation in North Carolina, he calls the Bronx District Attorney's Office. The ADA is assigned. He gathers the police paperwork. He talks to the detective. He talks to the complainant, arranges an interview. She doesn't show up. She's uncooperative. That's no great surprise in a domestic violence case. When she finally becomes cooperative, November of 2015, pardon me, may I briefly finish? The prosecutor quickly tells her to report the Manhattan allegations, moves forward with an arrest. From the moment she tells him she's ready to go forward to the day defendant is indicted is less than 2 months. At every turn, we move forward quickly. We ask for an affirmance. Thank you, Your Honors, for your time today.
Thank you. Counsel, you have 2 minutes for rebuttal.
Thank you, Judge. There's a lot to unpack there, and I'll do my best in 2 minutes. First of all, with regard to the flight to North Carolina, all I heard them say was that their evidence about that is the fact that Mr. Thigpen had a license that had been issued sometime in the past in North Carolina. There was no evidence in the record that he fled. The judge did make that finding, but it was based on a mistake about the date in question. It was May 2012, not 2013, that the North Carolina.
Okay, well, you've made a good point on that, so I think you can go to.
Sure. And second, I just want to address the idea that a showing of good faith is somehow sufficient. I mean, the standard in New York has always been good cause. That has not changed. Good faith is one relevant consideration, but not the entire consideration. And there was not good cause for the minimal investigation here. And then if I could briefly just turn to the prejudice question once again. Look, again, this was assuming that looking at the Sprint report that we have, which suggests that Ms. Robinson was chasing after Mr. Thigpen, it is reasonable to assume that this would have been a credibility contest had this case gone to trial. Mr. Thigpen could have used access to that witness, to any evidence that would support his version that he was chased first, and that 911 call was destroyed.
How do you respond to your adversary's point that, in fact, there were witnesses were found by the prosecution, and that once your client evaluated the situation, he spoke to his attorney and then pled guilty?
A few points. First of all, that occurred at the plea 2 years after this speedy trial decision was issued, and it's not clear from the plea transcripts whether that witness that is referenced by the prosecutor was in fact the same witness. And I would add that the state has totally different resources than a defendant has when it comes to trying to track down witnesses, and the state does not have to turn over all of its disclosure to the defense until a trial. So there's no way to know that Mr. Thigpen could have been provided with any of this, much less had the ability to track down the resources. And I just would add very quickly that the Sprint report does not contain the name of a witness. So the fact that Mr. Thigpen had a Sprint report does not help him investigate and find a witness. And for these reasons, we would ask that the court reverse the conviction and dismiss the indictment. Thank you.
Thank you. Thank you both. Next case for argument, Wallson versus 316 Bowery. Now, you represent,
Wallson,
and
316.
you represent Bleecker?
We're in the middle, Your Honor, so we
You're in the
represent-
middle? Okay,
We represent 46 Bleecker, so we are the
okay,
cross appellant and the...
okay. You could just have a seat back there, fine.
Okay.
I figured that.
It's a little unclear as to the choreography.
Okay, so you may begin.
Good afternoon. May it please the court. Paul Coppy of Rose and Rose for the appellant Wallson 316. Your Honors, this appeal concerns how to apportion liability for rent overcharges that ultimately came in at $2.3 million, none of which were collected by Wallson 316. There are three essential issues on appeal that are before the court, one of which we believe the court below erred on, one of which we believe the court below was correct on, and one of which is not 100% clear. The issue that we submit was decided erroneously by the court below, held that Wallson was liable for breach of a warranty in a contract between the original owner of the building, which was 316 Bowery, which I'll refer to hereafter as Bowery, and 4-6.
The theory is that Wallson was the successor in interest to Bowery, and that's why those representations concerning the legality of the rent were placed on Wallson. What's wrong about that?
Wallson never assumed liability for those warranties, and as is briefed fairly extensively,
Well,
I'm
sorry to interrupt you, but let's focus on the PSA, right? It's acquiring Bowery's interest in the property, quote, as is, correct?
yes.
Yes, okay. But doesn't it also go on to say, subject to all agreements of record to the terms of the master lease?
Yes, and the master lease.
And then taking my colleague's point, you're a successor in interest, you're on notice of the litigation, so it's difficult for me to really discern your argument.
Well, the master lease is quite clear that Wallson or any successor, any assignee under the master lease only assumed liabilities accruing subsequent to the date
Well,
of the
prospectively, but based on what?
assignment. I'm sorry?
What's that based on? That it's only
It's
prospective
based on the
liability?
language of the master lease itself. It's paragraph 39 of the master lease.
But doesn't paragraph 39 of the master lease say that in the event the premises, that's Bowery, is sold, which it was to you, to your client, that the purchaser has assumed and agreed to carry out any and all covenants and obligations of Bowery hereunder?
Thereafter arising. That's what it says.
I'm sorry,
I don't
where
see
does it say that?
sentence. I don't see it, do you see?
Sure. The seller shall be, and hereby is, entirely freed and relieved of all covenants and obligations of landlord hereunder, thereafter accruing. It's
Is that,
5 and 6 lines down.
Okay, but then it
Page
goes on to
148,
say,
go on.
and it shall be deemed, et cetera, and then going to the language my colleague read to you, that such purchaser has assumed and agreed to carry out any and all covenants and obligations hereunder.
Sure, because the master lease is an executory contract, and it's just standard language in any lease that if the lease is going to be signed, the assignee will be bound to carry out whatever executory covenants there are. It's not a provision to the effect that the assignee assumes liability for things that happened several years in the past.
But wouldn't your argument make more sense that if the qualifying language is in that, in the clause that I just read to you? Because certainly where the parties wanted to use thereafter, they used it in a very particular sense. In this instance, isn't this a little broader than that?
No, it's prospectively, the assignee will carry out the covenants and
What
obligations of the
about-
landlord. But the warranty in
Well,
the original
excuse me,
PSA.
Counsel,
sorry.
what about the section 14.1 where there was a carve-out for the rent overcharge litigation, which you obviously knew about when you entered into the MSA, and that it said you would continue paying counsel's fees in the overcharge litigation, and,
Sure. That's a provision providing for contractual indemnification.
right.
As the court below found, there's also common law indemnification, and the two serve fundamentally different purposes. Contractual indemnification provides that regardless of fault, no matter what happens, if there's liability, the indemnitor will pay. Common law indemnification, which we are clearly entitled to here, and the court found we're entitled to.
But actually,
required, may I just
can I ask you a
briefly?
question about that, counsel, since you raised it after the red light? If you are correct that you are entitled to common law indemnification, even though they are very specific, two different caps, aren't we rewriting the limitation provision?
Well, no, we're not. In order to prevail on a claim for common law indemnification, we will have to show a complete lack of fault on our part. We don't have to show that for contractual indemnification. That's kind of a strict liability. When the time comes, we will certainly be able to show lack of fault on our part, because at no time ever did we have any part, not only in setting the rents or deregulating the apartments, we never collected 1 cent of overcharges from any tenant ever. That's a pretty classic case for common law indemnification.
Okay, I'm going to ask you to have a seat. We're going to hear from Bleecker now. You'll have a few minutes later to respond to what your adversaries say. Good afternoon.
Good afternoon, Your Honor. May it please the court, my name is Sean O'Donnell. I'm an attorney with Herrick Feinstein, and we are counsel for the respondent cross appellant 4-6 Bleecker. We think that the Supreme Court got it almost entirely right. The only exception has to do with an indemnity provision that I want to make sure that we talk about today because it didn't get a lot of attention below, and I think that might explain why we are both a respondent and a cross-appellant. But first, as it relates to the primary issue before the court, which is whether or not Wallson is responsible for the breach of the representations with regard to the legality of the rent, Wallson assumed all of...
So how do you respond to their argument that it's prospective only and not retro?
Sure. So there's several problems with that argument. First of all, as Your Honor pointed out, it's inconsistent with the language in paragraph 39 of the master lease, where it says all of the obligations. It doesn't say bits and pieces of the obligations. And that's important because under the 2014 purchase agreement that was entered into between Wallson and 316 Bowery, it agreed to acquire both contracts, the 2012 PSA and the master lease, on an as-is basis. The master lease was actually recorded against the property. It's a 99-year lease with another 99-year renewal option, so it runs with the land. Under 2J of the 2014 PSA, it was actually annexed as an exhibit. And so there are about 3 places where Wallson expressly assumed all of the obligations under the master lease and under the 2012 PSA. The problem with their argument, if you play that out, would be that 316 Bowery could have falsely represented the rent, transferred it to Wallson, and the purchaser would be left without any claims at all because the master lease plainly provides that once 316 Bowery transfers the interest, it's not responsible anymore. It's the successor in interest. The court rejected almost the same exact argument in Hirschfield. It's briefed in our case. And there's simply no right way to read the 2014 PSA, the 2012 PSA, or the master lease that would suggest that they acquired anything short of the entire contract. It wasn't dribs and drabs. The language makes clear that it was everything under the agreements. And so maybe it's best if I jump ahead. I will say just one thing. Even if we were to adopt their argument that Wallson only acquired the interest after the assignment agreement, we don't agree with that. But the PSA makes clear that the obligations with respect to the rent actually survive until the closing. And that closing has yet to occur. I know today they're arguing otherwise, but as your honors will remember, in 2 other appeals before this court, that was not the contention. We actually sought an indemnity much earlier, and we were told that the indemnity claim was premature because the closing hadn't occurred. And we were also sought to file lis pendens because we were concerned about what they might do with the property while we were enjoined from transferring our interest or terminating the lease. And we were told we can't do that because title has yet to transfer because the closing hasn't occurred. So the closing hasn't occurred. The obligations survive at a minimum to the closing. And actually what the rider says is that those representations are paramount and survive the closing. So even if it's after the closing, they're still on the hook. I see my lights on, and so I want to just really quickly talk about the indemnity claims because that unfortunately didn't get attention with the Supreme Court. And so the problem is, if 4-6 Bleecker could be held in any way responsible to indemnify Wallson for claims relating to the rent obligations, that would turn the representations and warranties completely on their head. It would actually eviscerate them. So that's barred by canons of contract construction. What the Court of Appeals said in CBS v. Ziff Davis when it adopted Judge Learned Hand's decision and as to the definition of a reps and warranties is what that amounts to is a promise by the representative that if that fact later turns out to be false, you're going to indemnify the person that you're making that representation to, not the other way around. That's exactly what the Supreme Court's holding unfortunately does. Another problem, in addition to violating the canons of contract construction, is it's bedrock law that they Wallson, for the pronoun, stepped into the shoes of its successor in interest. They could acquire no greater rights than 316 Bowery had, and they're subject to the same defenses. Because of that false representation, that's a material breach of the agreement. Remember, that's paramount per the rider. That would absolve us of any obligation of indemnifying the other side. I think really the only reason why this happened is because of the limited time that was given to the lower court on this issue, but it clearly turns it upside down renders all of the other representations meaningless. I see my time's up. Thank you, Your Honors.
You'll have 2 minutes for rebuttal. Thank you very much, counsel.
May it please the court. My name is Gadi Gorin from Turek Roth Grossman, and I'm here today on behalf of Respondent 316 Bowery. Now, this court has a mountain of paper, and there has been extensive briefing on the issues. So I have just a couple of quick points that I would like to make. Section 14.1 of the 2014 PSA obligates 316 Bowery to indemnify Wallson for all losses, claims, damages, expenses, or liabilities, and I quote, suffered or incurred as a result of the overcharge proceeding in an amount not to exceed $250,000. Right. This necessarily subsumes 46 Bleeker's claims of rent misrepresentations, as those claims were suffered or incurred as a result of the overcharge proceeding. Conversely, the general indemnification provision in Section 10.13 of the 2014 PSA and in the assignment and assumption agreements relate to everything else. And what is everything else? All claims or unknown potential liabilities that were not suffered or incurred as a result of the overcharge proceeding. Next, common law cannot vitiate a specific limitation on indemnification that was negotiated.
But how about the distinction made? That's contractual, and we should be allowed to proceed with common law.
I'm sorry, Judge, I couldn't hear you so well.
Respond to your adversary's argument that that really pertains to contractual and it doesn't limit them from proceeding or seeking common law indemnification.
Yes, Your Honor. Your Honor, if this court were to accept Wallson's argument, it would render 14.1 meaningless, superfluous, and that would be an absurd result that is commercially unreasonable, and that would be contrary to the parties' reasonable expectations when they agreed to those specific limitations in 14.1. As Justice Chan found, the claims of common law and contractual indemnifications may coexist. However, in this case, we have a specific limitation to account for exactly what transpired in this case. Wallson must lie in the bed that they made in that regard. Wallson, a sophisticated real estate entity, knew what they were buying into, they knew what they were getting themselves into, and they knew that they were inheriting 316 Bowery's potential liabilities in the overcharge proceeding. I also think it's important to note that when the 2014 PSA was executed, 46 Bleeker had already asserted cross claims against 316 Bowery. Therefore, Wallson knew that those claims would be subsequently asserted against them as our successors in interest.
So they should have the same cap on the common law indemnification as they contractually agreed to in the contractual indemnification.
316 Bowery is subject to the monetary cap in 14.1.
Right.
Wallson, on the other hand, if they had wanted to negotiate a greater indemnification provision to their benefit, they could have. Or they could have walked away from the deal. They knew what they were buying into, they agreed to these limits, and they felt comfortable with them based upon their own independent due diligence that they conducted prior to executing the 2014 PSA. And finally, Wallson's course of performance. They agreed to be represented by the same counsel as 316 Bowery in the overcharge proceeding, and by executing a conflict waiver is a tacit admission by Wallson that there is no basis to seek indemnification beyond the limits of 14.1. Now, I'm cognizant of the court's time, so to the extent there are no further questions, I rest with the rest of my arguments that are in my papers.
Okay.
Thank you, Your Honors, for your time.
Thank you.
I would like in my rebuttal to principally address the assertion that because no closing has occurred, allegedly, my client should remain.
Well, I mean, allegedly, either a closing occurs or it didn't occur. I mean, it can't,
Well,
allegedly.
the term
I mean,
closed.
what do you have to prove that it closed?
The closing that occurred was the execution of the master lease. The master lease was specifically recited to convey the equivalent of fee simple ownership. Most tellingly, it conveyed complete dominion and control over the residential apartments. The full purchase price reserved under the original PSA was paid and accepted at the closing of the master lease. And most tellingly, for purposes of assessing the overcharge liability, the position that Bleecker would have the court assume is that until such time as there is a closing of title to the building as opposed to the master lease, all liability for overcharges must be paid by Wallson. This despite the fact that subsequent to the execution of the master lease, Bleecker actually collected overcharges for 2 full years before there was a resolution of the overcharge case. So Bleecker's position that they're advancing rather shamelessly to this court is we get to collect massive rent overcharges from 4 different tenants in 4 fraudulently deregulated apartments. We keep them. We don't have to give them back ever to anyone. It's Walsam's problem. Walsam did not have the ability to collect them. Walsam did not collect them. Walsam had no control over the rents. It's just, it's an illogical and frankly absurd interpretation of the record to suggest that there was no closing and therefore Walsam is liable for those overcharges. Thank you.
Okay, thank you very much.
May I proceed, Your Honor?
Yes, please.
I actually wasn't
Let me just
anticipating.
ask you, didn't the master lease basically say it was an interim document?
Yes.
It's in lieu of
Yeah.
sale document?
Yes, exactly, Judge Moulton. And there's a list as long as my arm as to why showing that the closing didn't occur and that even if it occurred, that they would be on the hook. So let me just kind of run through them because this was just another example of Walsam's willingness to distort the record and speak out of both sides of its mouth. So firstly, it's important to understand that there's nothing in the record suggesting whatsoever that we took rent, any rent whatsoever, after the court in October of 2015 held that the tenant plaintiffs were rent-stabilized plaintiffs. In fact, it's the opposite. At page 942 of the record, there's a sworn affidavit from Mr. Ballinger, who was the prior owner of 46 Bleecker, who said that they collected rents from, I think it was 2013, after they entered into the master lease, through 2015, and it says, quote, that they stopped collecting rent once the court declared that they were rent-stabilized tenants. So all we did was collect rent based on the representation that was given to us by Wallson and its predecessor in interest. There's nothing wrong or sinister about that. And at page 8 of the reply brief of Wallson, you can look and see they don't allege otherwise. All they claim is that we collected rent up until October 2015. But once the court found that the rents were rent stabilized, or that they should have been rent stabilized, notwithstanding the representations that Wallson and 316 Bowery made, there were no rents whatsoever that were collected. In terms of proof that the closing occurred, the master lease states that the 2012 PSA survives. Actually, at section 24, may I just finish this point and I'll stop? Section 24 of the master lease indicates that there still will be a subsequent closing. If there wasn't going to be a closing, then why were there 2 assignment and assumption agreements, one of which was the 2012 PSA? They assumed and assigned it because they still had an obligation to complete the conversion and transfer title to the property. That's the closing. So to argue otherwise is just, it's so disingenuous, and I rest unless your honors have other questions.
Thank you all very much.
Thank you.
Have a good afternoon. Next case for argument is 79 West 12th versus Kornblum. Me. Good afternoon.
Good afternoon. My name is Megan Larrywin from Patterson Belknap, Webb and Tyler. I represent the appellants Erica Stein and Arlene Kornblum. The question presented here is whether, under the House rules in effect at the time, Erica was required to obtain consent before acquiring her dogs.
So what were the House rules in effect at the time, which seems to be a big issue amongst everyone?
The October 2010 House rules were in effect at the time. The board
How do we know that?
The board disputes that, but throughout this litigation, it's our position that they should be equitably estopped from taking that position because in both their complaint, they alleged that the
Equitable estoppel, or you mean judicial estoppel?
judicial estoppel.
Well, let's assume that, or at least from my perspective, I'm not willing to buy into that argument. Is there another way to show, in fact, what House rules were in effect?
There is a wealth of extrinsic evidence which establishes that the House rules were in effect. In particular, several board members, both board president Eric Waller and board member Delia Guazzo, both acknowledged in internal email correspondence that the House rules had been amended in 2010 and have no pet consent requirement. The board has put forth nothing to generate a genuine dispute of material fact in response to this. They just point to the record and say there's no evidence, but there is. The emails, I think it's at 169 and 171.
So new shareholders come in after 2010. What House rules were given to those shareholders?
The October 2010 House rules.
And what's the proof for that?
There is an email from Eric Waller to board members indicating that if residents were to ask for a set of the House rules after 2010, they should be provided the October 2010 House rules and only those rules because the other House rules were no longer in effect. And regardless of whether the October 2010 House rules, if you were to find that they weren't in effect, the October 2005 House rules clearly also would be in effect, and they likewise.
Your adversary would go to it's the 99 House rules, I think, attached to proprietary lease. Why don't you think that argument holds water?
I'm sorry, could you repeat the question?
The 99 House rules, why does that argument not hold water?
The 99 House rules?
Wasn't it 99? The original House rules.
Oh, the original House rules.
Yeah.
They are no longer in effect because the 2005 House rules explicitly are stated, amended, and restated. New York courts have found that that language indicates an intent to supersede and replace pre-existing documents. In addition, they were disseminated alongside a summary document and a cover letter, which expressly stated that the 2000 House 5 rules were intended to supersede and replace the House rules, and the summary document.
But it also, there was other language that sort of problematized that, confused it by saying that the 2005 rules were not intended to change any legal rights and responsibilities of the co-op, including the House rules. So it kind of goes, the 2005 amendment seems to go both ways. You know, it has the language that supports your position, but also that language I just quoted, which seems to create ambiguity.
Thank you for raising that. If you read that sentence in context, it says that the legal rights and responsibilities of the co-op are not changed, but then it goes on to say that the House rules should be read in conjunction with the proprietary lease and relevant city and state laws. I think that language merely indicates that, like any documents governing a co-op, you should read the House rules consistent with other operative documents governing the co-op, such as the proprietary lease, and in addition, they would be subject to relevant governing city and state laws. That language can't be read to override the plain language of the rules that they are amending the original House rules, and that they are superseding and replacing the rules. And in fact, doing that would clearly undercut the reasonable expectations of the residents. Turning, and since I see that I'm running out of time, I also would say that because the language is clear and unambiguous, the court should reverse the trial court's order and judgment and enter summary judgment. But even if the court were to look to extrinsic evidence, we believe that the extrinsic evidence also weighs in favor of a finding that there was no pet consent requirement in effect. The board members themselves have not sought consent prior to obtaining their pets, and they have repeatedly acknowledged in internal email correspondence that there was no pet consent requirement in effect. And the board,
What, if any, application to this scenario does the administrative code of the city, the pet waiver laws, we call it, how does that affect this one way or the other?
the pet waiver rules?
Yes, pet waiver law.
Um,
The administrative code of the city of New York, which contains the pet waiver law?
I would have to look further into that, Your Honor. And lastly, if there is any remaining ambiguity, we would say that also the rule of contra preferendum, under that, any ambiguity should be construed against the board as the drafter.
Okay, we'll hear from the respondent, and then you'll have a couple minutes to rebut, okay? Thank you very much.
Good afternoon, Your Honors. My name is Stanley Kaufman. I represent the plaintiff respondent, 79 West 12th Street Corp. A number of issues exist in this case, which involves the harboring of 8 dogs and 2 cats in a small one-bedroom apartment. But the only issue...
In fairness, they were small dogs.
Yeah, that's what they claim. Yeah, Chihuahuas, yes.
Counsel, there's no question. This is a difficult case, and ultimately the court will be making difficult decisions in this case. But isn't your adversary right that it's the 2010 House rules are the operable House rules that we should apply to this case, and the case is decided the way the case is decided?
Well, the board, the board originally thought when this case was commenced that those 2010 House rules were in effect. The extensive discovery process, which happens in litigation, when the institutional memory is changed, and the board realized that there's...
words have meaning. So 2000 House rules say the amended and restated House rules.
Your Honor,
let me finish.
Sorry.
New shareholders who come in, they get those rules. So presumably between 2010 and 2021, the shareholders in that building are looking at the 2010 House rules to decide what they can do or can't do in conjunction with the proprietary lease, no?
I submit, I don't know what, it's not clear. Maybe some shareholders were given the 2010 rules. However, we submit that it's much ado about nothing, because the 2010 rules and the 2010, the rules dated 2010, which are purported rules, which we don't see any evidence were adopted, and the 2005 rules, which we acknowledge were adopted, both contain identical provisions relating to pets in a very limited section entitled Pet Supervision, which in no way contradict the original House rules and can exist in tandem with them. And both the 2005 rules...
the court below needs to know when the case is being litigated which rules to apply. And it seems to me, are you conceding now that the 2010 rules for the purposes of the trial below apply?
Absolutely not. I'm not conceding that because there's no evidence in the record that the 2010 rules were ever adopted by the board. However, what I'm saying is that it doesn't matter because the 2005 rules, which we acknowledge were adopted, say exactly the same. Not only do they say the same thing in the very limited section about pets, which just deal with like pet supervision, a very limited subject matter, but both the 2005 rules and the purported 2010 rules contain cautionary language saying that the foregoing is only a summary of policies most often encountered. It doesn't include every matter regulating residents.
How does that possibly give notice to the shareholders that they have to get prior permission from some? They're supposed to go back and look at the 1999 rules to discover that? Also, there was no cover letter that accompanied the 2010 House rules. What you have for the 2005 House rules is that cover letter that has this gloss, which is totally unintelligible to me, about adopting somehow or not adopting the 1999 rules. So there's nothing like that with the 2010 rules, right? There's no cover letter that accompanies them that creates that ambiguity, correct?
There's no cover letter, and again, there's no evidence that they were ever adopted.
So, but the evidence of giving house rules to shareholders is not a suggestion?
I think there's some anecdotal evidence of that in some emails, but there's nothing, there's no cover letter.
So words have no meaning, in other words.
There's no direct evidence that the 2010 rules were distributed to
So you're
shareholders.
saying there's no board resolution that said they voted on it and decided that.
Exactly.
But there were these emails, so, I mean, is the only document we can rely upon an official board resolution, and we can't rely on these emails where they told people, please give the new tenants, the new shareholders, the 2010 rules?
Let me try to simplify this. There are original house rules in the proprietary lease, which we claim were never repealed. The pet consent rule, the so-called pet consent rule, was never repealed, and there's no evidence of that anywhere.
So
in the
I don't
record.
understand then. The cover letter, which my colleague has pointed out, says these are 2005. 2005, the new house rules supersede and supersedes and it replaces the existing rules. That tells me, as a shareholder, okay, I'm subject to the 2005 rules. 5 years later, I get the amended and restated house rules. Tells me again, okay, as a shareholder, it's 2010, this is what I look at.
But both the 2005 rules and the purported 2010 rules say the same thing about pets, and they both expressly caution shareholders that these are not exhaustive. This doesn't regulate all matters relating to residency in this co-op. You got to look at the proprietary lease and the house rules.
Granted, because there's the pet law. And that's what the trial's going to be about, you know, right?
Excuse me, I didn't hear the question.
That's okay.
All right,
I see my time is up.
thank you very
Thank you.
much.
Thank you. I would like to address 2 points that my adversary brought up. One, that the 2010 and 2005 House rules don't deal with the same subject matter. That is false. They do. They have the 2005 House rules and the 2010 House rules have merger-like language. They both say that they're intended to amend the original rules. They also say that they're superseding and replacing the original rules, the cover letter alongside the 2005 House rules, that is. In addition, the general purpose of the House rules is all the same. They govern the conduct of the residents in the co-op, and the pet provision specifically governs the conduct of the shareholders as it relates to pets.
Counsel, let's assume there's an ambiguity as to which set of House rules controls. Maybe it's one of them, maybe it's multiple sets. What is the best evidence, if such an ambiguity exists, what would be the best evidence of the meaning of those rules? Or in the view of the parties, which set of rules governs?
I think the best evidence is the internal email correspondence from the board indicating that the 2010 rules should be provided to current
Is that
shareholders.
anecdotal evidence really not worthy of much weight?
Could you
Is that
repeat?
anecdotal evidence not worthy of much weight, if any?
I mean, it's contemporaneous email correspondence at the time telling the other board members that these are the rules that should be disseminated to the residents, and I think that's very persuasive because it illustrates what they were thinking in that moment, as opposed to in the context of this litigation. And turning back to the same subject matter argument, the two provisions in the 2010 House rules and in the original House rules, the pet provisions are in conflict. One has a pet consent requirement, one does not. And while the original House rules permit pets in all public spaces if carried or on a leash, the supervision provision does not. It does not allow them in the laundry room, community room, or roof. I see my time is up. Thank you for your time.
Okay, thank you both very much. The next case for argument is People versus Fleming. Good afternoon.
Good afternoon, and may it please the court, Alex Don of the Legal Aid Society for Appellant Gregory Fleming. The lower court erred in summarily denying appellant's motion for Dunaway and Mapp hearings in this case because appellant asserted grounds for suppression and his specific factual allegations were sufficient to trigger a hearing. Appellant challenged the legality of his arrest based in part on the insufficiency of the description that was transmitted from the undercover to the arresting officer.
Just to exclude one thing, it's clear that the defendant did not contradict the people's allegations regarding the actual sale, correct?
Correct, Your Honor.
It's about the transmission of the identification features of the defendant, and he, unlike the case Jones, I guess, he did say, I was one of many African-American men about my age. I wasn't wearing any particularly distinctive clothing, and therefore, we need to know what information was conveyed between the undercover and the people who actually arrested me concerning my appearance and how they could identify me and have probable cause for arrest, correct?
Effectively, yes, Your Honor. And yes, Jones is the case. Jones addressed precisely this situation, buy and bust. The court held, no, you don't need to actually deny participation in the sale to assert grounds for suppression. You can challenge the adequacy of any communication that may have taken place. In Jones, as we explained in our reply brief, the problem was that the defendant's allegations had been somewhat conclusory because the defendant didn't really make out any specific facts based on the information that he actually had, where the court said, look, if you don't have all the information, that's one thing. You don't have to plead information that you just don't have access to, but in order for your allegations not to be conclusory, you do need to give us what you have. And specifically, the Court of Appeals in Jones said, what you have at the very, very least is your own description of your own appearance at the time of your arrest and your own description of what other people around you at the time looked like. And in this case, appellant described himself as a 44-year-old black man, said that he wasn't the only black man in the area at the time, and said there was nothing particularly notable about his appearance that would preclude the possibility of misidentification. If the court has no further questions, I'll save my minute for rebuttal.
Okay. Thank you.
Good afternoon, Your Honors. My name is Patricia Curran, and I represent the people on this appeal. The court properly denied defendant's request for a suppression hearing as to physical evidence without ordering a hearing. He plainly did not set forth sufficient facts. He simply denied that he was engaged in unlawful activity at the time of the arrest.
But is it that simple? Wasn't there more, as your adversary was pointing out, with respect to his description, that he looked like anybody else on the street, not wearing distinctive clothing, et cetera, et cetera?
Yes, he now is arguing an alternative set of facts that he claims was sufficient to entitle to a hearing. But even under Jones, he has not made a specific number of facts that would entitle to it.
Why are those facts, as we've been discussing, why aren't they sufficient, at least on that one narrow issue, to get him a hearing?
Because he hasn't said enough, Your Honor. He claimed below that he was a 44-year-old black man, that he was not the only black male in the area when the police seized him, and that there was nothing particularly distinctive about his
Right, he
appearance.
wasn't wearing like a green baseball shirt or something like that, right?
That may be, Your Honor, but in Jones, the court in Jones specifically said that it was obviously within the defendant's ability to provide a description of his own appearance at the time of the arrest, a description that would enable the court to engage in a dope comparison. Just saying you're a 44-year-old black man is not enough. He knew what clothes he was wearing. He was talking about the fact there were other black people in the area. He could have described them. He did not give enough detail to entitle him to a hearing, even under his alternative argument of factual
So some factual averments under Jones that you're saying is not sufficient. It requires the detail that you're arguing to.
It certainly requires more detail than this defendant set forth here, yes. Yes, by the
Counsel,
by
if it
the
presents
court's
a close question whether the defendant provided sufficient allegations under Jones, wouldn't the better practice be to hold the hearing?
Your Honor, the defendant has to set forth facts to resolve a factual dispute at the hearing. If he hasn't set forth sufficient facts, there's nothing for the court to resolve.
So if it's a close case, whether the facts alleged by the defendant are sufficient under Jones, Again, wouldn't the better practice be to err on the side of affording a hearing?
Well, perhaps in the hypothetical, but that's not the case here, Your Honor. It is our very firm position that the defendant had the opportunity to set forth more facts about his appearance, and he failed to do so. Given that, the court was not obligated to grant him a hearing. If there are other questions about that or as to the excessive sentence point, I'd be glad to answer them. Seeing none, thank you very much.
Thank you.
Very briefly, Your Honors, I believe that the record clearly establishes that under Jones, appellant...
Do you think you needed to have more detail in there? I mean, did you think your client fell short at that time of giving enough details to require the court to have made that determination to give a hearing?
No, Your Honor, and Jones does not say that it needs to be a detailed description. Clearly, what the Jones court is concerned about is a defendant utterly failing to make factual allegations that support the claim. Here, generally speaking, what the defendant said was, I'm a middle-aged black man in a situation where there are other black men in the area, and there's nothing particularly notable about my appearance.
And it wasn't his obligation to start describing what every other black man about his age looked like in the neighborhood.
Exactly, Your Honor. If there are no further questions, thank you, Your Honor.
Thank you. Thank you both. Next case for argument is Dai Chai Life versus Aubrey Corp. Good afternoon.
Good afternoon, Your Honors, and may it please the Court. My name is William Regan with Hogan Lovells. We are counsel to the defendant appellants in this case. The trial court's fundamental error was in concluding that there's an ambiguity in the contracts at issue in this case on the threshold question of whether Daiichi has standing to enforce any alleged breach of the second-tier credit agreements, either as a direct party to the second-tier credit agreements or as an intended third-party beneficiary of the second-tier credit agreements. The trial court incorrectly concluded that there was an ambiguity in the contracts on the standing point based on the New York rule of contract interpretation, providing that contracts entered into at the same time for similar purposes can and should be interpreted together, and the customary integration or merger clause that appears in section 8.06 of each of the second-tier credit agreements.
What is from your perspective, what does the integration clause mean here in this case? What's your interpretation of it?
We'd interpret the same way that we've interpreted every merger or integration clause that we've ever seen. It means that the parties to the contracts had discussions and negotiations long before the final writing was executed, and all of those preliminary negotiations and discussions get merged with and into the final agreement. In our view, the trial court went too far. The New York rule of construction means that related contracts can and should be read together by a court when attempting to ascertain the party's intent. But the right to enforce a contract that you're not a party to is an entirely separate and different question. A standard integration clause, which this court has reviewed countless times, provides only that oral promises and other pre-contract negotiations between the parties are merged with and into the final written agreement. Basically, it's a very common provision found in most contracts that the parties will rely on the final writing, not anything that was previously discussed. The rule of construction in the integration clause cannot be used to give Daiichi the right to enforce an alleged breach of the second-tier SBC agreements, particularly given the facts here and the express terms of the contracts. First, the fact that there's a two-tier structure here is no accident. It was quite purposeful. By Daiichi's own admission, the parties first considered a one-tier structure that had Daiichi as a party to the only lending agreement. And then the parties switched to a two-tier structure to achieve a specific business objective. That business objective was time. time for the second-tier SPC to submit and recover on an insurance claim in the event of non-payment by the underlying fund so that Daiichi would not have to face an event of default. In paragraph 27 of the complaint, Daiichi alleges, as initially proposed to plaintiff, the Aubrey structured finance transaction involved plaintiff making a loan to a SPC that Aubrey would create solely for the transaction. The SPC would invest the capital. Then in paragraph 30 of the complaint, Daiichi alleges, as previously noted, during the negotiations of the agreements, the parties ultimately agreed to use a two-tier structure, with 2 loan agreements per investment rather than 1. The rationale for this two-tier structure was to ensure timely payments to plaintiff. Daiichi goes on to explain the mechanics of the insurance structure in paragraphs 31 to 33 of the complaint. But these admissions are fatal to Daiichi's case. Daiichi cannot in one breath allege that it chose not to be a party at the second-tier level in order to achieve a business objective, and then later, in the course of litigation, demand to be given rights to enforce that same second-tier agreement. Further, the signatories to the second-tier agreements left no doubt as to who they intended to be actual parties. The cover page of the agreements does not identify Daiichi as a party. Introduction language.
Also, Section 804 helps you too, doesn't it, with respect to the third-party beneficiary argument?
Yeah, so Daiichi makes both arguments. We're a party or we're a third-party beneficiary. I think Section 80.8.04 is absolutely fatal to the third-party beneficiary claim. There are a dozen or so cases cited in our brief that say where a party affirmatively disclaims the intent to create any expressed or implied third-party beneficiary rights, Daiichi's claim must fail.
But with respect to Daiichi's claim as a party to the contracts themselves, these were not two separate. I understand your point about the 2 tiers, and there were business purposes therefore, but these were not 2 separate and distinct transactions. The tiers sort of worked together. Daiichi loaned the money down to Tier 1. Tier 1 then ceded the money to Tier 2, and the interest was supposed to flow back up. So it wasn't as if these were 2 separate, independent, severable contracts, correct? I mean, these agreements were specifically designed to work together.
Absolutely, the contracts are related. There are 6 separate transactions that the parties negotiated. Each one has 2 separate credit agreements, a first-tier agreement and a second-tier agreement. And if the question is, can you look at the first-tier agreement to figure out and understand the meaning of the second-tier agreement? Absolutely. That's black-letter New York contract law. That's the rule of construction that we've been talking about. But it's a completely separate analysis to say, does a party to contract A have a right to enforce an alleged breach of contract B? And that simply is not the case here. If Daiichi wanted to have the rights of a party, it can and should have negotiated the 1-tier structure. But
What about the claim for breach of implied covenant of good faith and fair dealing? They don't have to have a contract, they don't have to be a party to a contract to allege that claim.
Well, if they don't have rights to a contract, they can't allege breach of an implied covenant for a contract that they're not a party to or a third-party beneficiary of. They are a party to the first-tier contract. Right. And there is a claim for breach of that contract, and I think the trial court left that particular claim ambiguous as to whether or not it's dismissed or not. The claim there is that, and I see that I'm out of time. Do you mind if I finish answering the question?
Well, I'll tell you what, let me hear from the other side, and we'll give you have a couple minutes to
Certainly,
respond.
thank you.
Thank you very much.
Thank you, Your Honors. I don't want to breach protocol. My name is Mark Goodman. I am from Baker McKenzie. I'm appearing pro hoc vice. I don't know if I need to be introduced or if I should just launch in. I have my local counsel here to introduce me if that's...
I think you are supposed to do that. Not great at this. So do you want to step up and just do that, Counselor?
Good afternoon, Your Honors. Christina Cerruti from Baker McKenzie, counsel for plaintiff respondent. Mark Goodman is also from Baker McKenzie. He has been admitted pro hoc in connection with this appeal, and with the court's permission, Mr. Goodman will present oral argument this afternoon.
Okay, thank you. For the record, we appreciate you having done that.
I try to follow the rules, Your Honor.
Yeah, since you're coming to visit, you may as well, right? Thank you very much. You may proceed.
Thank you, Your Honor. Just to address a couple of the points that counsel made in his opening remarks, he said that this is a standard integration clause like every other integration clause. With respect, it is not. A standard integration clause talks about the agreement being the only agreement, no other contracts. This integration clause, 8.06, says that the agreement, the loan documents, and another letter, other letters relating to payment constitute the contract between the parties. The loan documents in 8.06 is capital L, capital D. That's a defined term in the contract. The loan documents are defined to be all of the loan agreements between the parties, the necessary agreements, which constitutes both of these. As Your Honor pointed out, this is all part of one deal. This is, as counsel even referred to them, it's a first tier and a second tier agreement within the same structure. We're not talking about a share purchase agreement and an insurance policy. We're talking about tiers of the same deal. And if you look at the loan document definition in here, it includes specifically exhibits to these agreements. And if you look at the exhibits to the agreements, it says that the second tier agreement is one of those loan documents. So that document becomes the contract between the parties.
So Daiichi doesn't have to be a third-party beneficiary to run afoul of that clause. It can be a party.
Correct, Your Honor, and that's what we've alleged in our complaint. We allege in our complaint alternative claims. We're a party, but if we're not a party, we have other rights, either third party or otherwise, under these contracts because of the way they're structured. Our primary argument is that we are a party to those agreements because they've been incorporated.
So respond to your adversary's argument that, for example, with respect to section 4.01, your adversary argues, these are conditions for closings, there's a reference, that's all it is. Why is that, at least at this stage, at the pleading stage, not a good argument?
Because that's not what it says, Your Honor. It doesn't say that's all it is. That's his interpretation of it. We've alleged in our complaint, because we are at the pleading stage, this is a motion to dismiss, and I don't need to remind this panel what the standard is for interlocutory appeal on a motion to dismiss.
We get them all the time.
Yes, correct. But we've alleged in our complaint that these terms in this contract, specifically the prohibition against indebtedness, the prohibition against entering into or engaging in transactions, and the fact that the way that these are structured, these contracts are structured, and the language of the structure makes them one deal, one transaction under which we're a party.
Aren't they, as my colleague pointed out, they're mutually dependent on each other, aren't they?
100%, and the language says that, Your Honor. I mean, it's not just extrinsic evidence, which we believe will support that once we start getting in discovery in the case, but the language of these agreements says that. That's the language that I was pointing to in 8.06. It says there are three different things that make up the contract between the parties, and one of those things is the loan documents, and that's a very broad, that encompasses a lot of different contracts, including the second tier agreement. So it's necessarily part of the same deal, as your colleague indicated. So from our standpoint, there's no question that the contract is clear. You can't enter into it. You can't incur debt. It doesn't say you can't incur debt except unless you want to prepay the amounts due under the contract. It says you can't engage in a transaction. It doesn't say unless you want to engage in a transaction to prepay the amounts due under the contract. And it says that the contract between the parties is all of these different agreements. And Justice Oettcher said that that's enough, as a matter of pleading, to get past the pleading stage, and let's see what the evidence shows as far as what makes up the contract, what are the parties' rights under the contracts, and that's what we're in the process of doing when we're not in front of your honors, re-arguing the ruling that was already made.
Sir, is Section 804 fatal to your breach of contract claim insofar as it's premised on a third-party beneficiary?
No, Your Honor, we don't believe so, because that provision talks about, that there are no rights unless they're created, unless you're a party to the agreement. We're saying, again, we're a party to the agreement, so therefore we have, again, some right. If it's not traditional variety third-party beneficiary, there's some right as a party to the agreement that we would have under those contracts that are incorporated. So even though they're separate contracts, there's still an obligation or rights under those agreements because of the language of these contracts. But again, as I pointed out before, the primary argument is that we're a party to the contract and we have direct rights as a party.
Thank you.
Thank you very much.
I think the controlling issue under New York law is what is the intent of the parties as indicated by the words they chose to put in the contract. We
But
talked
can
about.
we really decide that at this point? Because you agree that the contracts are mutually dependent, right?
No, I
You
agree
don't
that.
agree? You don't agree that there's a waterfall feature flowing downwards and then flowing back up, correct?
I agree that the two contracts are related to a particular investment, but there's no language in one indicating
If money didn't come from Tier 1, what would Tier 2 do?
Tier 2 wouldn't have any money without, so they're related, but there's no language
No,
in the
they're
contract.
mutually dependent, not just related.
I wouldn't agree in that. You see in the case law other contracts saying we hereby incorporate by reference the obligations in contract
I
B.
understand that language is
There's
not
nothing
here.
to that effect here.
I agree.
What is here is clear language indicating who the parties intended to be, parties or third-party beneficiaries.
But wasn't the intent of this whole, at least part of the intent of this structure was for plaintiff to get the income that took a time to get? I mean, that's, they didn't want to prepay. That was what the second tier people offered, was to prepay. And they said, no, we want the interest income. That's the whole reason we set this whole thing apart. That's why they did not accept the early payoff. So weren't you frustrating the whole intent of the whole setup, the whole, the whole reason that they structured the deal this way, or at least arguably?
I think we would have a very fundamental disagreement with that point. There were 6 transactions in total. Transaction number 1 has no prepayment right. And so the defendants have not attempted to prepay that contract and admit that it's not prepayable.
Okay, but the others have.
The others have a prepayment right. And the defendants exercise that right, and it's the HE bringing this lawsuit that is frustrating the structure of the purpose. The HE bargained for a prepayable instrument, and they're now contending after the fact and trying to change the structure after the fact to take the position that this was in fact not prepayable at all.
Okay, well, I thank you both. Does anyone? Okay, I thank you both very much. We'll take another look at these papers.
Thank you, Your Honors.
Next case for argument is People versus Mario Tingling. Good afternoon.
Thank you, Your Honor. Molly Schindler on behalf of Mario Tingling. May it please the court. Your Honors, the second and fourth departments have consistently and unanimously held that points under SORA cannot be assessed on a theory of accessorial liability in the context of sex trafficking or promoting prostitution cases.
Let's assume you're right. What does it reduce the points down to?
To 75 points, which is the
And what's
lowest
the presumption
score.
at that point?
I'm sorry, I didn't hear you.
It's level 2, right? Still level 2?
That's correct. However,
So does it really matter whether it's 100 or 75?
It does for the purposes of a downward departure application, because this court has considered, among the totality of the many circumstances that are considered in a departure, whether somebody is on the cusp of one of the levels or the other, whether they're very far from it. So here there's a big difference between 100 points, which is nearly a level 3, and 75 points, which is the lowest possible level 2 score. So we would ask the court to reach it, and also to bring this department in line with the second and fourth departments' consistent holdings on this point.
That precedent, that precedent that you're relying on is essentially that you can't have accessorial liability in this context unless you have a specific intent with a specific person, right?
That's correct. You would have to share the intent of the customer in a sex trafficking case, which is difficult to prove because the shared intent in a sex trafficking case is between the victim who's engaging in the contact and the defendant in the case.
But both the John and of the victim and the defendant, your client, wanted her to have sex for money.
The ultimate goal was the same between the three parties. I think a good analogy is one that people v. SG brought up, which is a drug transaction. In that case, every party involved wants the drug sale to take place, but there's still a difference between the intent of the buyer versus the intent of the seller, and that's explored in the agency defense where there's a middleman and you have to assess whether he's an accessory to the buyer and that he's trying to sell drugs versus he's an accessory to trying to buy drugs, or he's an accessory to the seller who's trying to sell them. So
And
there's a difference.
that reasoning of Justice Kahn, when she was in the trial court, that's been adopted by the Second and Fourth Departments, correct?
That's correct, Your Honor. So we would ask this court to adopt that reasoning.
So going to the downward departure, why should there be a downward departure? You have a 30-year-old man who brings a 15-year-old girl into the city for prostitution. Why should there be a downward departure?
Your Honor, there's no question that this crime was serious. Mr. Tingling was sentenced to 15 years in prison, and he is a registered sex offender because of it. However, a downward departure considers a person's risk at the time that they're being released to the community, not at the time of the sentencing, and it is therefore based on all factors in the case, including those that have transpired since the sentencing, which is particularly stark in Mr. Tingling's case because over the course of more than a decade in prison, he underwent a very significant transformation, particularly after the death of his father. We went into a lot of detail about this in the brief, but in around 2016, the evidence shows that he truly transformed. He took advantage of the opportunity to rehabilitate to the point of having an exceptional performance in sex offender treatment. And exceptional is not my word, it's his treatment provider's words. They use that word to
But there's a
describe him
balancing. Isn't
repeatedly.
there a balancing? Using your words or the words, the treatment is exceptional, but also sort of balancing the underlying conduct too. Isn't that something that we have to engage in?
Yes, Your Honor, all of those factors.
So why is that treatment while he was in prison, why does it balance more in favor of your client as opposed to the prosecution?
Because looking at the person that Mr. Tingling was at the time that he was released from prison, and in fact, this hearing took place a couple of months after he had been released, his conduct is very different now at the present time that the court is assessing his future risk than it was at the time that he engaged in this.
But wasn't there a notation that the defendant should, that it was recommended that the defendant should continue with one-on-one counseling upon his release to address criminal thinking patterns and personal triggers? So there was still concerns, because you said we're supposed to take into effect what was going on at the time he was being released, and that was still part of his record even after the 15 years.
That's true, Your Honor, and we certainly agree that there was still more work to be done, although every registrant who is on parole is required to participate in additional sex offender counseling when they're out in the community, even when they've already completed it in prison, and that is certainly appropriate.
This is a special indication on the record.
Right, but Your Honor, in addition to the sex offender treatment, he did exceptionally well in his other rehabilitative programs, and he was released with very strong family support. So all of those factors, Justice Singh referred to all of the balancing of the totality of the circumstances. We submit that it does balance in favor of a downward departure. Thank you.
Okay, you'll have 2 minutes on rebuttal. Thank you. Good afternoon.
Good afternoon, Your Honors, and may it please the court. Julia Gorski on behalf of the people. The SORA court correctly adjudicated defendant a risk level 2 sex offender, and it was provident for them to deny his request for a downward departure. Accessorial liability applies in this case. The defendant could not have intended for anything else to happen to the victim besides someone to have sexual contact with her.
How is this case different from the Fourth Department case?
So it's hard to determine the differences in the cases cited by defense counsel because in all of them, either the people concede the points, so then the court doesn't go into discussing the facts of the case or why they held that the people would have failed. And another issue is that it's not necessarily discernible of whether the people even argued for a theory under accessorial liability. So it's hard to answer that question of why they are correct if they are, but under these circumstances, we believe that they are not, and this court should not adapt that precedent. And as Your Honor noted, even if defendant was erroneously assessed the 25 points, he is still a risk level 2 offender, And given the heinous nature of the crime and his misbehavior in prison and all of the other factors that the court took into account, any mitigating factor in support of a downward departure was significantly outweighed. If there are no further questions, we ask that you affirm the judgment. Thank you.
Thank you very much.
Just very briefly, the Second and Fourth Department precedent is clear. Many of the cases actually cite to People v. SG in their conclusion, which demonstrates that they are following that same reasoning. And Blue and Kennedy in particular are from 2020.
Well, I mean, again, getting past that, because it still keeps them on level 2, on the cusp of level 2. But don't the cases say that it has to be a very rare occasion where there can be a downward or upward modification? But here we're talking about downward. Why would this be one of those rare cases under all the circumstances?
Sure, the word rare does appear in some of this court's precedents, but I guess rare is not defined. And I would say that this case does present one of those circumstances where level 2 does not appropriately assess who he is now. One striking thing about Mr. Tingling's performance is that the prison actually restored over 3 years of good time based on that transformation I described beginning in 2016, and he had not had any disciplinary infractions since 2017. That, coupled with the excellence in his programs and his family support, this is one of those cases. So that is what we are asking for. Thank you.
Thank you. Okay, the next case, thank you both. The next case for oral argument is Tihan versus Apollo Management.
Good afternoon, Your Honors. My name is Howard Justfig. I represent the plaintiff, Hal Tihan. The issue I'd like to discuss with you today is that Justice Perry was incorrect when he dismissed, as a matter of law, on summary judgment, Mr. Tihan's complaint that he was discharged for retaliation in violation of the city human rights law. Mr. Tihan had asked the company to investigate claims of discrimination against him.
Counsel, excuse me, wasn't Mr. Tihan already subject to a PIP before he filed his complaint internally?
Could you repeat that?
I'm sorry. The plaintiff was subject to a PIP, an improvement plan, before he filed his internal complaint in 2016, correct?
That's not correct, Your Honor. When we asked the representative of the defendant, Sampson, when they put the PIP into effect, she said, she didn't give an answer. She said, oh, while we were discussing.
But I'm sorry to interrupt, but the the reason for the PIP was because there had been a couple of prior years, some concerns about not his work performance, but his inability to communicate with colleagues, et cetera, right?
That's
that was
correct,
going on
John.
for a couple of years. So wasn't the PIP, irrespective of when it was placed, wasn't it as a result of the evaluations as opposed to his complaint?
Well, I don't think so, Your Honor, because the defendants acted inconsistently with those evaluations. In 2015, they had the evaluations, and they gave him a $90,000 bonus, making him the highest paid manager in his group. Then, in 2000...
Counsel, to interrupt, the status of his evaluation was meet some, but not all, expectations in 2015, correct?
That's correct, Your Honor.
And he had a similar evaluation in 2016, correct?
That's also correct, Your Honor. and they gave him in 2016 another bonus.
Which was smaller than 2015's bonus.
Right, but a considerable amount of money. It was $65,000 or $70,000 then. These actions are inconsistent with discharging the man on that basis.
What was the target bonus, however?
The target bonus was $125,000, but the defendants maintained that that was only for year one, and that afterwards it was discretionary. My client didn't quite understand that, and that's why he complained about discrimination. He thought he should have been getting the higher bonus. While they accused him of not being sweet enough to vendors and other representatives of the company, he was in a position where he was responsible for their IT operations. If it didn't work properly, they'd be in big trouble. He couldn't.
So you're trying to explain his behavior, is that it? Are you trying to explain his behavior?
That doesn't explain his behavior. In total, Your Honor, he was asked to get it done. And sometimes to get it done, you have to be a little bit tough. And that's what he was. Okay. Under the city human rights law, it's the defendant's obligation to show that there couldn't be any other reason that a jury could say, oh, you should not have discharged him on this basis. If one of the motivations is wrong, that means they're not entitled to summary judgment. They have to show that no jury could find retaliation here. This court, in the Kim against Goldberg-Weprin case, and a year ago in McCormick against NYU Langone, found that it was the defendant's obligation to prove as a matter of law that it was not motivated by retaliatory animus. And that they didn't do here. We relied on the Second Circuit case of Mahalik. There was a woman who had issues with her work performance, but she had been sexually harassed. They didn't fire her because of her work performance until she mentioned her sexual harassment allegations, and then they fired her. That's what happened here too. They didn't discharge him until he complained that he'd been discriminated against. Thank you.
You'll have 2 minutes for rebuttal.
Okay, thanks.
Thank you, counsel.
Good afternoon, Your Honors. I may please the court. Brendan Killeen from Morgan, Lewis & Bacchus on behalf of the defendant respondents.
So can you address the retaliation argument? Because that seems to be probably the stronger case here. Why isn't there an issue of fact based on the timing of the complaint and the termination? I understand that the PIP was in place around that time, but why isn't it sufficient for that to go to the jury?
Well, as the court noted in the Melman case, this court noted in the Melman case, employers are permitted to proceed with gradual advanced actions against employees who have continue with their progressive discipline practices. The plaintiff's argument is essentially the second that I'm found to have been a poor performer, I should be terminated. But that's not what employers do. If that was the case, no one would ever have a chance to improve their
No, I think what he's saying is, well, I got some poor performance reviews, but we're going along, I'm getting bonuses, I make a complaint, and a few months later, I'm terminated.
Well, so first in terms of the timing, as Ms. Sampson testified at her deposition, the decision to place Mr. Tihan on a performance improvement plan occurred while Mr. Albelli completed the performance evaluation, which was done prior to any complaint by Mr. Tihan.
Was he put on notice of that?
He was then, during the During his meetings about his performance evaluation, he was informed he would be placed on a performance improvement plan. That was initially intended to be 60 days, and which Mr. Albelli and Ms. Sampson discussed with Mr. Tihan before putting into effect in February. In fact, Mr. Tihan was able to provide information and modify the performance improvement plan before it went into effect. When his performance didn't improve over those 60 days, Mr. Albelli and Ms. Sampson provided him an additional 30 days that they're not required to provide, but gave him additional time to show improvement, consistent, sustained improvement. And rather than accept the feedback he had gotten, as he's shown over the 2+ years of receiving performance feedback, he disregarded and ignored that feedback. And finally, even after getting an additional 30 days, the company determined that it could no longer employ him and terminate him. That was 5 months after he had raised his complaint, 4 months after that complaint had been fully investigated, and there had been no findings of any wrongdoing. The complaint was initially that Mr. Verdier, who is his manager's manager, was the one who was allegedly discriminating against him because of terrorist attacks in France in July 2016. When you look at the timing, there is no change in the performance reviews that he was receiving from Mr. Albelli and feedback from his colleagues prior to those terrorist attacks to after. There is no evidence that Mr. Verdier was involved in any of the actions taken against Mr. Tihan during his employment. And Mr. Tihan himself said, Mr. Verdier never said anything discriminatory or retaliatory against me. He wasn't involved in any of these actions, and he admitted he never retaliated against him. So the investigation found exactly what Mr. Tihan testified to.
They never found any emails that had any language in it that could have supported plaintiff's claims of discriminatory or retaliatory.
Correct. The only allegations are with respect to his direct manager, Mr. Albelli, and it is that twice over a 3-year employment that he was referred to as the Turk. He claimed that there was an email that referred to him as being a Turk or Turkish. We went
loud
through,
Turk, not just referring to his nationality, but the loud Turk.
I forget if that was a said statement or if that was claimed in the email, but regardless, we went through all of the emails from Mr. Albelli and Mr. Tihan. There is never any reference to being a Turkish, loud, etc. And that was, part of the investigation. It was found that there was never any comments like that that anyone else could attest to.
But viewing the evidence in a light most favorable to the plaintiff as the non-moving party, and keeping in mind, particularly with respect to the claims under the city human rights law with its special remedial purposes, how does that the plaintiff's testimony that remark was made not raise an issue of fact, at least under the city human rights law?
Well, as this court found in Bennett, and as it reiterated in the Melman case, not every city law claim gets to proceed to a jury. You have to provide that there's some reasonable evidence to support your claim. Defendants have set forth legitimate business reasons, and Mr. Tihan then had the burden to show that they were pretextual, misleading, or that there was any evidence that he had was treated differently than non-Turkish individuals or non-Muslim individuals. He did not meet his burden once it was turned back to him under any standard, and that's what the trial court found. It looked at it under McDonnell Douglas, under mixed motive, under direct evidence, and every combination thereof, and found that he did not meet his burden. Thank you, Your Honors.
Thank you, counsel. You have 2 minutes.
I'd just like to clarify that Mr. Tihan was not under a PIP at the time he made his complaint of discrimination. That occurred later. In her affidavit, Sampson said it occurred on December 1. She had a conversation with Mr. Albelli on that date. The written evidence shows that there was no possibility of that because Mr. Albelli was not available to speak with her at that time, and he wasn't available to speak with her until later. So the PIP was not in place when he made that claim. And if they claim that it was in place, that's another issue of fact which would deny summary judgment. If there are no further questions, I'll end here.
Thank you. Thank you both. The next case for oral argument, stop irresponsible Brick development. Good afternoon.
Good afternoon, Your Honors. May it please the court, Jack Lester on behalf of the appellants. Your Honors, what is at stake in this proceeding is adherence to 72-21 of the zoning resolution, which governs the issuance of variances in the city of New York. Why that's important is because all property owners must adhere to the zoning laws of the city. In order to be given an exemption or an exception, the law creates 5 criteria that a developer must adhere to in order to obtain a variance. Because this was a not-for-profit organization, there were 4 criteria. Returning a profit was not one of the criteria. However, in this case, the E finding, which is the criteria which requires that the variance be the minimum necessary to afford relief, was not, there was no evidence to support the E finding in this case. There's long precedent at the BSA, the Board of Standards and Appeals, which reviews variances, that when you come forward to apply for a variance, you must show that that is the minimum necessary. In other words, what are the alternatives? What are alternative variances that you may obtain that could afford you the relief? In this case, the applicant did not come forward with any evidence that this was the minimum necessary. No alternatives were put forward. In fact, the community, the opposition to the variance, went to great lengths to show that there could be alternatives, but the BSA rejected.
Well, it didn't, I mean, the respondents did look at that claim, and they first noted the very scaled-down plans compared to the 2013 proposal, which was nixed because of community complaints. And they found that this proposal, even if though there was an alternative one, was, was minimal. Didn't they? I mean, they did look at it very carefully. I know you don't agree with the results, but.
Well, there were 2 problems with that. Yes. First of all, the application that they were referring to as a prior application, right, wasn't this one. Secondly, that proposal that was put forward previously years ago was a much more extensive, right, variance than this. And then when the community came forward and showed the BSA that there could be alternatives, the BSA rejected it by saying the community didn't have the knowledge, the insight, the expertise. They didn't have access to geotechnical reports, foundation reports. They didn't have the information necessary to show that this could be an alternative, and therefore it was discounted. But what was ironic and interesting was when the BSA wrote their resolution, they utilized the community proposal, which they had rejected during the hearing. They said, we're not going to consider that. But then when they wrote their resolution, they said there were alternatives put forward by the community. But that cannot be a replacement for the applicant coming forward to show that this was the minimum variance necessary, because they had the engineers, they had the geotechnical experts to show what could be done. And so on the one hand, they rejected what the community did, but on the other hand, they utilized that to show that those were alternatives they were rejecting. So it's inconsistent and somewhat, I would contend, somewhat hypocritical on that point.
Didn't the BSA, with respect to that element, engage in what the agency is supposed to, which is a discretionary balancing of the different facts that have been put forth? I thought the BSA, with respect to the minimum variance necessary, looked at the programmatic needs of the FRIC, looked at and considered your client's proposals and found them insufficient in light of those programmatic needs, and also that they noted that the FRIC's current proposal was scaled down compared to its prior proposal. So, I mean, isn't that simply the board, and again, you don't have to agree with what they did, but the board simply engaging in that discretionary balancing in
Well, there are
arriving at a determination?
There are 2 points. Absolutely correct that they engaged in the balancing test on the A finding, that the as-of-right proposal could not fulfill programmatic needs. They did that. That was the A finding. But the E finding is totally different. The E finding, you shift away from programmatic needs, which is the A finding, and then you look at, well, how can you achieve your programmatic needs with lesser alternatives? And that they didn't do. They showed that they couldn't fulfill their programmatic needs as of right, and that was the A finding. But they never got to the E finding, never produced evidence on that. And that's a fundamental flaw, because 72-21 says you have to act in accordance with each finding. The BSA is charged with that responsibility, to act in accordance. The preamble to the statute says, act in accordance to each finding.
Okay, well, let's hear from the respondents, and you'll have a few minutes to respond, Mr. Lester. Thank you.
Good afternoon. Mackenzie Phillip for the Board of Standards and Appeals. This court should affirm because the board rationally granted the Frick's application for a variance. As your honors noted, the board gets a lot of discretion in deciding these things. The board members are experts in these areas. They went to the Frick, they toured it for a significant period of time. They saw the staff members there toiling under extremely difficult conditions. They looked at a number of proposals for renovations, and they.
Now, when you say number of proposals, where did those proposals come from? The Frick made a few different proposals?
The Frick submitted 3 potential development plans. One was as of right, what they can do without a variance.
Okay.
Everyone agrees that
was not sufficient.
Yes. The second one, they gave information about the previous year's plan, which was quite extensive.
The 2013?
Exactly. And then they presented this one. So they presented 3. There's literally nothing.
So there was the one that was too small and one that was too big,
Right.
and this one was
This one
sort
is
of in
Goldilocks, right? So this one is the one that everyone agreed, well, not everyone, but the board and
But is
and the
counsel
Frick.
right that all the findings weren't made, that you made one set of findings, but not the second set of findings that's required?
No, they made all the findings. I believe it's at pages 59 through 65 of the record. That's where they made the E finding. They went into great depth, great detail about why they think this proposal that the Frick has put forward is sufficient. And they analyzed 2 other proposals that the petitioners had submitted. There is no requirement in the statute anywhere that the applicant present more than one plan even. But here, the board looked at 5 different plans. It's decided that the one that the Frick wants to do is completely rational and will meet their needs without giving them more than what they need.
It seems like I'm reading from the record, it's in their report, or order that says specifically that the other plans would not accommodate the museum's program, and went on to.
That's exactly right. Like things like they need to keep just rational things like wanting to keep all the classroom space together, wanting to make the building ADA compliant, wanting to keep all the library books together. To do all of these things, they need a certain amount of space. And the board toured the building and determined that this was a completely reasonable
There was
proposal.
a lot of discussion about the music room, which I understand is not there anymore.
Yeah, it's not there anymore, that's right.
What did you determine about that? And that seemed to be a big concern of the petitioners.
Yes, the board determined that allowing the Frick to demolish the music room would actually lessen the extent of the variance required. I mean, that's the thing is, if you need more space, you can get it in 2 ways. You can repurpose internal space, or you can build a bigger building. If they couldn't destroy the music room, they'd actually need a bigger building. And that is what the variance actually goes to, is the bulk of the building. This is not a use variance. This is a bulk variance. Nothing in the zoning resolution limits the Frick's ability to demolish an internal room. They did not need a variance to do that. They could have demolished the music room and then sought the variance, and they wouldn't have done anything unlawful.
Did they claim some type of historical significance to the music room because of some of its history?
The petitioners claim that, yes, but the Landmark Commission reasonably determined that there are no notable features of the music room that were so worthy of preservation. that the Landmarks Commission had in fact rejected the application to designate it as an internal landmark. The determination that this work would not have a significant environmental impact was completely rational. The board gave a very hard look to all of this and rationally rejected the petitioner's claims. Thank you.
Thank you.
Good afternoon, Your Honors. Jeffrey Braun of the Kramer Levin firm for the Frick Collection. The core question is whether there's substantial evidence in the record before the board to support its conclusions. And we have a 7,700-page record. But if you just look at the 26-page decision of the Board of Standards and Appeals, I think it becomes obvious that the board really very carefully analyzed and thoroughly analyzed the evidence and made the necessary findings, all of the necessary findings under 7221.
What were the findings that petitioner claims you did not make, the E findings as opposed to the A findings?
Yeah, the E finding is a finding that the variance you're getting, in other words, the variation between what the zoning resolution allows and what they're going to let you do, whether that's the minimum relief necessary to allow you to achieve what it is you are entitled to achieve. And the board analyzed that question pretty thoroughly in its decision. The evidence included, look, I'm sorry, Your Honor, we have a building that has had no major upgrade or expansion in 85 years. And we have an accreditation report from the American Alliance of Museums that says our building was inadequate for a contemporary museum. A very extensive programmatic needs report was submitted to the board showing all of the deficiencies of the building, what our programs are, why the building is deficient, how this project would address that. The commissioners, as was noted before, all visited and toured the building and saw for themselves and commented on the record about how problematic the current building was. The board, we submitted...
Was that both for the art, where the art exhibits would be shown, as well as the back offices? Was it both?
It's everything, and the library. Well, the core rooms that are from the original mansion from 1914, which are these glorious rooms where the Frick family lived and entertained. I mean, they are great, and no one's changing them. It's this sort of ancillary space that we have. It's this library, which is one of the most important art reference libraries in the world. That's inadequate. The facilities for doing art restoration, which is terribly important, are clearly defective, inadequate light, bad location. There are just a lot of things wrong with the current building because it's just so dated. And we submitted an as-of-right proposal, which, you know, that means a zero variance proposal. That's the most minimal thing you can submit.
And that was found not to be adequate.
It's inadequate. The board was advised of the prior, the 2013 project, which would have added like 50,000 square feet of above-ground space to our building. We withdrew that. New team designed the current project. It adds only 11,000 square feet of floor area above ground. It achieves that by repurposing existing rooms and by doing a lot of excavation to create new underground space. But even with the new project, we will have only 27% of the floor area that the zoning resolution allows at this site. So it is, you know, a pretty minimal project. The other side objected. They had an architect. He came up with a couple of different alternative proposals that involved a lot more excavation. You're talking about excavation under a historic, you know, more than 100-year-old building, and the board was persuaded that those projects, those alternatives were not realistic. So we think it's a very, like I said, it's a minimal project. And the only way you could save the music room and achieve the museum's needs would be to either build a bigger building, which would require a larger variance, or destroy other historical components of the building, which everybody, I think, or at least most people, and we think, more important and more valuable and more significant than the music room. You know, there was obviously a lot of attention given to the environmental issues. The issue is whether the board identified the relevant areas of concern, took a hard look, made a reasoned elaboration. Board had a 582-page environmental assessment. 98 pages were addressed to the impact on historic resources, had input from the Landmarks Commission, which had twice ruled that this room, this music room that petitioners claim they care about, was not sufficiently distinguished to be worthy of designation as an interior landmark. Thank you, Your Honors.
Thank you very much, counsel.
Your Honor, the critical issue in this case was, did the applicant conflate two separate elements of the law? The A finding, which allows for a variance if you can show a hardship. In other words, they couldn't adapt their programmatic needs within the zoning. That's one element. The second element is if you get past that, if you can show that you have a hardship, then you have to show that you've looked at various alternatives so that you're not obtaining more of a variance.
So let's talk about that. You know, the argument that I found most resonating was the argument your adversary just made, that in order to meet the needs of the museum to preserve the music room, which is a shame it's destroyed, of course, I'm sure everyone feels that way, was a much larger proposal, which the community opposed years ago.
Right.
So isn't this, in effect, the best they could do under the circumstances?
Well, that would be true if they had produced evidence. The problem was the previous application was withdrawn. That received universal opposition. They withdrew it. So now they're saying we're coming back with a different application, and because the other application was withdrawn, we're now exempt from showing any alternative that can reach the same objective without the extent that we're applying for here. So they kind of bootstrap. They said we withdrew the last one, so now the law exempts us from having to show a minimum variance. This is a new application. They have to fulfill the evidence under each finding. There's no question there was no alternative proposed. The community did try to put forward alternatives, but the BSA said you don't have the proper evidentiary foundation, but then did not request that the applicant come forward to show any rationale as to why what the community had proposed was inappropriate or unable to be achieved. There was simply no alternative put forward, and because one of the findings was not adhered to, it does not comply with 72-21, which is the issue.
Okay, we will take another look at this. Thank you all, counsel, very much. Have a nice afternoon. Next case for argument is Elberg versus Crabapple Corp. Good afternoon.
Good afternoon. May it please the court. Levy Hubner and Associates, PC, for the plaintiff appellant Ruben Elberg. This matter, which I understand the record is large, a little over 5,000 pages, and 12 related cases in multiple counties and jurisdictions. However, the simple nexus, in my view, comes down to the error of the motion court. The motion court was in a rush. Just like the motion court issued an order of removal on January 21, 2016, which was reversed by the Appellate Division. Likewise, on December 4, 2000.
That was in the Crabapple action, correct?
Yes, correct.
And then, actually, before we issued our decision on appeal, the Crabapple action settled, correct? I apologize, Your Honor. Yeah, me too. Before we issued our decision, the crabapple action actually settled, right? Not, oh, okay, so that was dismissed with prejudice without involvement of my client, Mr. Elberg. Mr. Elberg, the judge ordered, the motion court so ordered a dismissal with prejudice of that action, but not with involvement of Mr. Elberg. Mr. Elberg was not involved in that dismissal with prejudice resolution of that case, because before Your Honors, before this court reversed, so Pesner was able to complete a merger with the insiders. So the nexus that I'm looking at is after Pesner directed her mother to put 30 medallions in bankruptcy, Roar and Rem, Royal Real Estate One and Royal Real Estate Management, became adversarial parties to a Chapter 11 bankruptcy in the Eastern District before Judge Lord. And pursuant to statute, since Pesner claimed that Roar and Rem belonged to the estate, that created an automatic stay. But the motion court mistakenly decided that the bankruptcy court had never issued an order of a stay. However, it doesn't go by an order of the bankruptcy court, it goes by statute. Secondly, Pesner, in a repeated motion in this action, the same motion identical to the motion that Pesner made before the motion court in the crabapple action, was exactly the same and had absolutely no live controversy in effect. If Your Honors want, I could explain those, why they're not live. The repeated motion repeats the same motion regarding Rubin's Fitness, which was disposed of with prejudice, like Your Honor, Judge Moulton pointed out, and that case was dismissed with prejudice. Well, we only found that, counsel, we only found that there was an issue of triable fact about your clients. In the appeal, we only found that there was an issue of triable fact concerning the fitness of Mr. Elberg. Correct. However, that first, when there was the motion was made in the first case, that case was dismissed with prejudice.
So what about, counsel, I understand the argument, but what about in this case? Why couldn't the issue of Mr. Elberg's fitness be resolved in the context of this litigation?
So this court directed, specifically given the conflicting submissions vis-a-vis the LLCs and the LPs, as whether completing the project or accepting a buyout was the best course of action. The motion court acted prematurely when it granted the motion to remove Elberg as an acting co-manager without holding an evidentiary hearing. However, this court specifically said vis-a-vis the rights of the parties with the LLCs and the LPs, and whether a buyout or whether a build of the project was better had to be determined, and the motion court never determined those issues. Secondly, the motion court could decide, even if it could decide the issue of management of the LLCs. The co-executors...
Can I stop you for a second? Does this litigation, what's the predicate for this litigation? What's the basis? What is your client seeking here?
Oh, Mr. Elberg, for 20 years, built this project with his father and diversified their medallion holdings to build hotel projects. And his sister, Ms. Pesner, came in after she became co-executor.
Counsel, I don't want to speak for Judge Singh, but I think he had a more specific question. He was asking you, this case is a declaratory judgment action.
Correct.
Specifically about just 2 November 2012 LP agreements, right?
Correct. So
that's all this case is about, right?
This case was a declaratory judgment action, and Judge Barak, the court can take judicial notice of it, found that the November 30 agreements existed when Mr. Elberg has a 40% waterfall, and the court also found that Mr. Elberg is a 40% minority member of the LLCs. That's Judge Barak. Secondly, the motion court considered
removal, but even if they consider the removal of a manager, the motion court had to decide whether they're going to leave it to the jurisdiction of the surrogate, which is already looking at that issue, or whether they're going to, this motion court would apply its discretion to review that. And if it did so, then the motion court had to apply the surrogate's court procedure standard under 711.
Okay, counsel, we're going to hear from the respondent. You'll have a few minutes to, for rebuttal. Okay, thank you.
Thank you very much, Your
Thank you very much, counsel.
May it please the court, may it please the court, Charles Liebman for respondents in this appeal. Look, you're right, you're correct, Your Honor. The crabapple action was settled before this court issued its ruling on the prior appeal. The only matter that was before the lower court in this case was the propriety of Mr. Elberg's appellant's actions.
So let me stop you there. Case is settled, case is over, right?
Yes.
So then, was this issue preserved in the stipulations or any of the ensuing documents?
So this issue was an interlocutory matter that was not central to any of the matters in the pleadings of the prior action.
That's not answering my question. Was it preserved in the stipulation?
It was preserved because it was never decided factually here. The only thing that happened here was that it was reversed based on procedural matters.
But the case was discontinued, correct?
That case was discontinued.
Not preserved. So presumably, the hearing with respect to fitness has to arise out of the instant matter, which is a DJ action seeking certain declarations with respect to the validity of partnership agreements.
Correct.
Was the issue in any way raised in the pleadings with respect to the plaintiff's fitness?
His fitness was not a matter of the pleadings that he filed. It was a matter of before the court. We appealed to this court's jurisdiction because he filed his case under that jurisdiction.
Did you file some sort of counterclaim asserting the fitness with respect to the fitness of Elberg?
A specific counterclaim saying that no, this was a
So then what's the basis for the court to have been even able to hear and make a decision on the issue of fitness?
Well, the matter of the entities was before the court for purposes of determining the contractual, the propriety of contracts before the court.
The thing is, this decision that's on appeal today was issued 3 years ago by Judge Ramos, right?
Correct.
And hasn't, I mean, Judge Barak has made some other decisions. I mean, it just seems that everything in these cases happens at strange times, like you appeal after you've resolved other issues. I know, you know, to get us, we end up saying things I'm sure are problematical. Hasn't Justice Barak, who now has this case, granted plaintiff's motion for summary judgment on his declaratory judgment action already?
That act matter is actually on appeal before this court, and
Oh, that's
actually
on
was
appeal.
fully briefed under 2021-00562. So all the matters which counsel has just raised as being determined by Judge Barak are actually before this court on a separate
And
appeal.
what's the story with the surrogates court? What's going on in the surrogates court?
There are other matters going on in the surrogates court involving the parties, but they didn't impact anything here because there was no removal of an executor or any impact on executor powers in any decision before this court. All those matters remain before the surrogate. The only thing that happened here was the court examined the actions, and based on the testimony of appellant himself, he admitted to obstructing tax filings. He admitted to obstructing a foreclosure proceeding. He admitted to not surrendering an agreement which could have cost liquidated damages. It was the testimony given by appellant which was brought before the court showing his unique unfitness to further be a manager of these entities. And we appealed to the court under the business corporation law asking for that removal because of his actions against the LLC's interests. Thank you.
Thank you.
So if I may shortly, Your Honors, the issues that counsel now raised regarding obstruction of tax returns, misrepresenting of funds, Reuben Ray refused to open bank accounts to the LLCs. Those are all allegations they raised in the opposition in the appellate briefs. It wasn't raised in trial in the hearing before the motion court. It was only raised in their post-submission papers before the motion court or in the papers before the appellate division. Secondly, in the surrogates court, there's already removal proceedings for violating fiduciary proceedings pending before the surrogates court, which is exactly why it should have been determined. Secondly, and ironically, Hesner insists that Reuben should be removed from LLCs, which she insists that he's not a member of. And she also insists that Reuben should be removed from acting on behalf of limited liability partnerships, which respondent argues that are not in effect. And those issues had to be determined before there could be a removal. And finally, Pesner insists that the projects lacked funding, and Reuben acknowledged that while he didn't have funding on January 7, 2014, by July of 2014, there was EB-5 funding, and those EB-5 funding was fully funded, and that's what the insiders used, that exact EB-5 funding, to get the bridge loans with the letters of intent that Judge Ramos refused to consider. And that's why the court below simply erred in jumping the gun and deciding issues that should have been resolved before getting to the final.
All right, counsel, thank you very much. Thank you both.
Thank you, Your Honors.
Have a good
afternoon. Thank you, Judge Kapnick. Thank you, Judge Shulman. Thank you, Judge Singh. Thank you very much, Judge Moulton. And thank you very much, Judge Higgins.
Have a great afternoon. Thank you. People versus Kirby Velez. Okay, you may begin. Good afternoon.
Good afternoon. May it please the court. Hannah Gladstein for the appellant, Mr. Kirby Velez. Mr. Velez pleaded guilty, having been denied crucial Brady information about the only witness who identified him as having committed this offense, a witness whose testimony went straight to the heart of the prosecution's case against him. The court below abused its discretion when it denied Mr. Velez's motion to withdraw his plea, and we're asking this court now to vacate his plea. The court also erred by requiring him to plead guilty merely and able to obtain an evaluation to be considered for diversion. And in the alternative, if the court denies his request to vacate his plea at this point, we're asking the court to reduce his sentence in the interest of justice. So the only witness to have identified Mr. Velez as having sold drugs in this case was an undercover who had previously misidentified 5 sellers.
Is that, Counselor, is that Brady?
Yes, it is Brady. Under the standard...
It's not impeachment?
No. The standard that was articulated by this court in Martin for pre-plea disclosure of material that tends to exculpate is whether the material would have materially affected the defendant's decision to plead guilty or proceed to trial. In Martin, this court answered that question in the negative because the undisclosed information about the officers was unrelated to the facts of the case or the substance of their testimony. But here, an undercover's entire job is to engage in drug transactions and then identify the seller. And
I'm sorry, I guess I'm confused. Would this kind of impeachment evidence, would it tend to establish your client's innocence?
The question that the jury, yes, the question that the jury would be considering is whether this undercover accurately, truthfully identified Mr. Velez as the seller in this case. So
that sounds like impeachment because you're saying in prior cases it wasn't done, right? That he had problems, there was misidentifications, and that's something the jury could consider to determine the identification here?
Well, I think we don't know what exactly the issue was, whether it was misconduct, whether it was that he is terrible at his job and just gets it wrong. But a jury, I think, hearing this cross-examination of this officer would not believe that this identification was accurate or truthful, and would not believe that Mr. Velez had sold drugs. That's the sole question in this case. Was the identification correct? So there was no other direct evidence of his guilt in this case. So this testimony was dispositive. If the court has no other questions about the Brady point, I'll move on to the point about the diversion statute. It is plain that the diversion statute requires the evaluation to occur before a plea. And that's not what happened here. What happened here was a really coercive situation where a person who really was in need of treatment had to forfeit his rights to trial in order just to be considered.
Did defense counsel raise that issue?
Defense counsel did not raise that. We concede that it was not preserved. However, it's our position that this is an issue that's not subject to preservation because it falls within the exception for matters that are plain on the face of the record. You just need to look at the statute to see that this procedure is not countenanced. Indeed, we believe that this statute is so clear that this is a situation like Rudolph. And
okay, so let's go to the merits. So the merits are the judge essentially says, look, I don't think this is going to happen, right? That diversion is not going to occur, right? And it's highly unlikely.
Yes.
She said he's going to be rejected.
And that's what happened.
Well, she said that.
And he insisted still to go through with it, no?
He did. The reasons she cited for why she believed that he was not going to be accepted were reasons that, first of all, didn't come to pass, but also, she said, well, I don't think he really has a drug problem. The man was on over 100 milligrams of methadone. I mean, clearly he had a drug problem. She also said, well, I think his prior criminal history might be an issue, but she also acknowledged that he was, in her words, paper eligible, meaning that they were not a statutory bar. So while she did raise concerns, they were matters that,
well, concerns are, I'm not sure. It sounded to me that the judge was pretty sure that this was not going to work.
I think ultimately it's not her decision, though. It is the decision of the treatment court, and a defendant should not have to give up his bedrock constitutional rights in order to get to that point where, professionals trained in evaluating a person's suitability for treatment can make that call. It's not, it was not her ultimate decision, and he had a right, as contemplated by the statute, to have that decision made after the benefit of a full evaluation by people trained in making that assessment.
Thank you, counsel.
Good afternoon, again, and may it please the court, Stephen Kress on behalf of the people. This was impeachment material, the prior misidentifications. It's not exculpatory, and whether or not its disclosure would have affected him going to trial doesn't determine whether or not it's impeachment or exculpatory. Exculpatory information is information or evidence that proves you did not or could not have committed the crime. That doesn't, these misidentifications don't actually do that here. It's not like they put him somewhere else at the time of the crime or suggest that somebody else did it. It goes to the undercover officer's credibility. This is impeachment material, and for that reason, as this court held in People v. White, it doesn't have to be turned over prior to the guilty plea. And I also want to say there was absolutely other evidence of guilt in this case. It did not rely exclusively on the undercover's identification. There was pre-recorded buy money that was found in the defendant's possession. So there certainly was other evidence of guilt here. I will also address counsel's point about the defendant pleading guilty before going to diversion. The judge made very clear she didn't believe that he was eligible. She communicated this to him. He entered this guilty plea with eyes wide open. And I should point out, perhaps more importantly than anything, this exact claim was raised in People v. Berrien, and this court rejected it. And in fact, that was another case coming from Judge Ward. And what the court said in that case was that Justice Ward explained that diversion wasn't guaranteed or even likely, and advised the defendant of the sentence that he would receive.
But wouldn't it be the better practice to, I mean, why compel a guilty plea? Why not go through the evaluation, and then if he's diverted, that's fine. If not, then come back and then continue the plea negotiations. Isn't that less coercive?
I mean, you could certainly do it that way, Your Honor.
Well, I'm asking you, isn't it less coercive?
Well, I don't think it's I wouldn't say that it's coercive to do what Judge Ward did in this case. The defendant knew exactly the deal that he was entering into, and I don't think she coerced him in any way, and I don't think she was obligated to go through the process that defense counsel suggested when she was 100% confident that he was going to get rejected, and of course that turned out to be true.
But for different reasons, I think, right?
Well,
it wasn't, her thing was that he was selling drugs and apparently had violent anger issues.
Right. It's not exactly clear to me because I think we're getting, a description of Justice Nunez's decision kind of secondhand, but that was the issue that was raised, correct, that it had to do with a separate incident. But unless the court has any other questions, we'll just ask that the judgment be affirmed.
Thank you, counsel.
A few points very quickly. Berrien did not reach the issue of the matter of statutory interpretation that we are presenting here today. Your Honor is correct that he was ultimately denied treatment for reasons, different reasons. After he went through the assessment process with people who are trained in doing that, they did find that he had, he addresses it in his address to the court at sentencing. They concluded that he had some kind of anger issues, some kind of incidents with treatment providers in the past, which he vehemently denied. So it was a completely different matter, and this is a highly coercive process, as Your Honor identified. This is a man who has made it plain to the court that he is in extraordinary psychiatric distress. He said that he believed he would be hospitalized within a matter of days. So to require him to plead guilty when obviously he is really in need of that assistance, it is not what the statute contemplates, and this is precisely why.
Counsel, is a takeaway point from Berrien, however, that this sort of issue has to be raised below and therefore preserved, and that's why the court in Berrien didn't reach the merits?
Your Honor, I don't think the parties in Berrien litigated whether this matter is in fact subject to preservation. We are putting that issue before the court. We maintain that because it is plain on the face of the record, the statute is so clear, as in Rudolph, that this is just not something that needed to be preserved. Finally, back to the Brady issue, the buy money that was supposedly recovered from Mr. Velez, even if it was recovered from him, that is not dispositive of whether he conducted the drug sale. So to say that that is evidence of his guilt, it is perhaps, if there were a credible identification, it would perhaps corroborate that, but possession of the buy money alone is not dispositive of the question whether he sold drugs. Thank you.
Thank you very much. Thank you both. Jewish Press versus Kingsborough Community College.
Good afternoon, Your Honors. May it please the Court, Samuel Spurgell, on behalf of Aaron Law, PLLC, for the Jewish Press petitioner and appellant. Your Honor, this appeal arises from a wrongful denial of petitioner's FOIL request for complaints arising from anti-Semitism and anti-Zionism made by employees and students at Kingsborough Community College. Specifically, the appeal relates to a relatively new provision of the FOIL statute, in particular, the mandatory fee shifting provision. There are two elements to that provision, Your Honor, that a party, the applicant...
Right, it's not disputed that you substantially prevailed.
Correct,
So
Your
the
Honor.
question is, did the agency lack a reasonable basis for withholding the documents?
Yes, Your Honor, and appellant's position is that they did not maintain and they did not have a reasonable basis at the administrative level. In particular, Your Honor, I'd like to address, at least begin to address, the Jackson-Lewis inquiry as the Kingsborough has framed the issue. In particular, they believe and they argue and rely on the law enforcement investigation exemption to relieve them as a reasonable basis to deny the application. In fact, that reliance, Your Honors, is unreasonable. What we have here is a factual allegations by employees in one category of documents and students in the other category of documents that is being looked into by Kingsborough Community College.
But isn't the law that internal civil investigations can come under the law enforcement?
Absolutely, Your Honor.
So why doesn't this investigation of the allegations fall within that?
So not every civil investigation by municipal authority or agency under Medreos would qualify as an exemption under the law enforcement investigation. For example, Your Honor, if Kingsborough Community College retained a consultant to investigate whether or not their buildings complied with the building code, certainly I don't think that that would qualify as a law enforcement investigation as the Court of Appeals set forth in Medreos. In Medreos, the state education department specifically was engendered in their essence to conduct audits for purposes of fraud or other misappropriation of public funds. In this particular case, a human resource complaint, which is essentially what was done by the employees making complaint of anti-Semitism.
A very serious complaint. The institution acts by finding a reputable law firm to conduct an investigation to get to the bottom of the veracity of the complaint, et cetera.
Absolutely, but it's petitioners, appellants, I'm sorry, Your Honors. It's appellant's contention that that does not rise to the level of a law enforcement investigation. Because, Your Honor, what that means is, and if the court accepts the respondent's position, any municipal or public authority can hire any consultant to come in under the guise of that's a law enforcement investigation that would immunize the agency from producing a document under FOIL.
I don't see it that way. I just see it as an attempt to conduct an independent investigation of allegations by a body who is able to conduct such investigation.
So an agency monitoring their internal conduct for general and routine purposes, I believe, is different than a law enforcement, even on a civil side. They need to maintain that their routine policies, administration, students, and what happens on their campus comply in a general sense with the laws as anybody else does. It would be no different if Google had a, if I just may be allowed to finish. If Google hired somebody because they had complaints of anti-Semitism on one of their employment sites, they have a general routine function. Medreos and the law enforcement investigation exemption is different than routine. And I believe, at least in Medreos, the fact that it was to enforce a specific audit right that the legislature enacted and anticipated and specifically delegated to the agency is what Medreos was talking about.
Thank you, counsel. You have a minute for a rebuttal.
May it please the court, Zach Shapiro for respondents. Plaintiffs, Jewish press has failed to establish that there was no reasonable basis for the initial denial of documents here. Medeiros defined law enforcement as any effort, in whether civil or criminal, to detect and punish violation of the law. And that's exactly what the Jackson Lewis investigation here was designed to do. That's at page 101 of the record.
Well, what would have occurred if, for example, they had found instances of discrimination?
Well, it says at 101 of the record that employees could face disciplinary action. I can't say what exactly that form would take because ultimately the investigation found that there was no intentional discrimination that would warrant any discipline. But the point is that this was an effort to detect and punish potential violations of the law. And even if your honors disagree that the law enforcement exemption applied, the standard here isn't whether it applies, but whether the agency had a reasonable basis for concluding that it applies. And they have failed to show that there was no reasonable basis. They made no effort in their opening brief to challenge the Division of Human Rights investigation, which I think the exemption clearly applies to that, and the documents here were only turned over because that investigation had ended.
Right, but the focus is on the investigation by the law firm. I think that's...
Of course. I'd be happy to answer any other questions Your Honor has.
Well, sir, what do you say to your friend's point that by virtue of hiring an outside private law firm to investigate this, as opposed to doing it in-house, any protection you might otherwise have enjoyed under the law enforcement exception was stripped away?
I don't think that's right, Your Honor. For example, if you look at the Court of Appeals decision in Xerox, the court there said that if an action would be exempt under the FOIL if taken by agency employees, then it doesn't lose that exemption if taken by independent consultants hired by the agency. And that makes sense. He says that this is an effort to conceal routine practices. It's not routine that an agency hires an independent or hires a private law firm. Those kind of efforts involve huge expense. They're not routine, and this was a genuine, sincere effort to try to make sure that there was no discrimination going on, and to the extent that there was, to ensure that proper disciplinary action would be taken.
So is it your position that it doesn't matter whether the investigation is done in-house or by a private, outside private entity? It's the nature of the inquiry that we have to look at?
Yeah, that's exactly right, because the exemption says whether the documents were compiled for a law enforcement purpose and disclosure could interfere with a law enforcement investigation. This investigation clearly falls under the definition of law enforcement as Medeiros set it forth, which is just an effort to detect and punish a violation of the law. And to the extent the agency was ultimately wrong about that, and Supreme Court ultimately denied the exemption, that at least established a reasonable basis for denying the documents. I'd be happy to answer any other questions Your Honors have.
Thank you, Counsel.
Thank you.
If I may briefly be allowed to reply, Your Honors. With regard to the law enforcement investigation, the law firm was retained, and I specifically refer, Your Honors, to page 77 of the record, which is an affidavit, which is the respondent's answer to the petition. They reference that Jackson Lewis was retained, and specifically in paragraph 44, Your Honors. They retained the law firm of Jackson Lewis on May 30th. That's well after both the initial FOIL was filed and after the denial. So to the extent that Kingsborough Community College may have been shielding and trying to insulate themselves from production, certainly retaining counsel after the FOIL and after the FOIL was denied, certainly reliance on that exemption would be unreasonable at that time. At the administrative level. Furthermore, Your Honors, they also allege with regard to the student complaints that they're exempt based upon FERPA. The federal, I'm sorry, Your Honors, if I just may finish that point.
Finish your thought, go ahead.
The Federal Family Educational Rights and Privacy Act. A decisional case law and both opinions from the Committee on Open Government previously decided that FERPA does not, or FERPA only relates to and protects records relating to an individual student's performance. Certainly, complaints about anti-Semitism or other forms of discrimination on a college campus is not specifically what Committee on Open Government and the other cases have previously decided. So their reliance on that exemption at the time is unreasonable, and the petitioner would only need to prevail and show that any exemption was unreasonable at the administrative level in order to prevail on its appeal and be entitled to an award of fees under the fee-shifting provision. I thank Your Honors for the time. I apologize for going over.
Thank you. Thank you both. And now we have ALP versus Moskowitz. What? This one is a mistake. This was okay. Wait 1 second. Okay, if you can introduce yourself and who you represent.
Sure, may it please the court, good afternoon. I'm Gregory Clarick. I represent Gene Luntz and Gene Luntz Management.
Okay.
2 actions on appeal in front of the court. In these cases, among other things, ALP makes the dramatic claims against Mr. Luntz and his management company, seeking to claw back 6 years of commissions that ALP itself paid to Mr. Luntz. They have no basis to do this.
Well, you know, look, let's remember this is a 3211 motion, right? The plaintiffs, there have a lot of claims in here. They're very substantial complaints in these 2 cases. And there's quite, you know, an interesting history and story here. So, I mean, you may say that they're very out there claims, but there seems to be some very some substantial things alleged in here about what's going on with this artwork.
Your Honor, the complaints certainly are lengthy. And the question is, do they allege facts that make the claims, in particular, the ones that we focused on appeal? This first claim is this overarching claim that ALP seeks to recover 6 years of commissions that ALP paid to Gene Luntz. The court below sustained the claim on the single finding or the single idea that the complaints sufficiently alleged undue influence by Mr. Luntz and his management company over Adam Max, the son of Peter Max, to obtain these 6 years of commissions. As I'm sure you're aware, and as we write in our brief, the undue influence claim requires that allegations be made under CPLR 3016 that particularize the proof of undue influence over Adam Max. That
Well,
requires...
there were claims that Adam sat in the office and listened to white noise, is that what it's called?
White noise?
All day long, and kind of allowed other people, even though he may have been the CEO at times, that he was allowing other people to go ahead and run this whole, you know, huge company that was up until 2012 run by his father.
That's true, and I recognize those allegations. And while I don't think that those are particularized allegations that show that he's susceptible to undue influence, but more importantly, there's no...
Let me stop you there for a second. Remember, this is a pleadings motion. So the only issue is it sufficient on the face of the pleadings? So as my colleague was saying, opportunity, right? Opportunity, because there's an allegation of Adam's condition. Motive, your motive, make millions in commissions. Why isn't it sufficient at this point to sustain that claim?
Well, what I'd like to focus on is the actual exercise of undue influence over Adam. There's not a single instance in the complaint that explains and alleges in a particularized way, let alone in any way.
But isn't that what discovery is for?
Well, when we look at CPLR 3016 that requires a particularized complaint, I think actually that's what the complaint is for.
Yes, but we all know that sometimes all of these, the knowledge is not necessarily in the hands of the plaintiff when they come out with their complaint. They don't know everything. But Mr. Luntz is an art dealer, correct?
Mr. Luntz was the sales agent for ALP over the course of these years.
And he was selling all of these artworks of Mr. Max's with a relationship with Park West when it was, and getting enormous commissions, when in fact, it was Mr. Max who had like a 50-year relationship with the owner, I forgot his name right now, of Park West.
Well, even the complaints admit that Mr. Luntz had a long-term relationship both with Mr. Max and with Park West. And they also show that over the course of these years, 2012 to 2018, while Mr. Luntz, it's true, made a lot of money in commissions, ALP itself made a huge multiple of that amount of money. ALP's and Mr. Luntz's incentives were entirely aligned.
But assuming, I'm sorry, counsel.
Mr. Luntz made.
Counsel, assuming for the purposes of the truth of the allegations of what they're saying, isn't that sufficient to get them past this pleading stage?
Well, I don't think
everything you say, I think, makes perfect sense and subject to summary judgment, those arguments. But at this point, why is that not sufficient?
Well, the law in New York is very clear that as a general matter, companies cannot claw back monies that were paid, compensation paid to employees for completed work. So a
Even,
completed
even,
periods of
I'm
employment.
sorry, even disloyal employees or allegedly disloyal employees?
Well, yes, well, it depends on how the claim is made itself. This claim is, this claim has been argued and found by the court below that undue influence, led to these payments. But there are not allegations that our client engaged in any undue influence over Adam Max to obtain these payments. I'll reserve the rest of my time.
Okay, thank you very much, counsel. Who is next?
Good afternoon, Your Honors. Michael Futterman, McCusker, Anselmi, Rosen, and Carvelli on behalf of the appellant Park West Galleries. Your Honors, I'd like to introduce Paul Schwepp of the State Bar of Florida, who has been admitted pro hoc vice to argue here today.
Okay, and are you the one that asked me for 4 minutes? Is that right? Okay, so, counsel?
5 and 2, Your Honor?
What?
I think 5 and 2.
Okay, fine, thank you. Okay, you got your 5 minutes.
Thank you so much, Judge. May it please the Court, Paul Schwepp on behalf of Park West Galleries. Stripped as the complaint must be of its rhetoric and its legal conclusions, its labels, as to Park West, which is in a very different position than Mr. Luntz, who is alleged to have been an insider, an agent of ALP. Park West and ALP had an arm's-length buyer-seller relationship that went on for years, and in its substance, the complaint alleges the following, that there was a purchase order that was entered into between Park West and ALP that was signed by the then president of ALP, Adam Max.
And there is a claim there in this huge complaint that, not as huge as the other one, but still long enough, that there was some undue influence or some, forcing him to sign it. I mean, there are claims there that this was done and that at the end you were rushing very much to get all these, this deal done when things were, these lawsuits were starting. But yeah, I mean, I know it was signed by Adam, but maybe under duress. That's an allegation, right?
They are allegations, but beyond that, the complaint attaches as Exhibit 20, a purchase order signed by the then president of ALP to sell artwork to Park West. So the issue then becomes, ALP has alleged that Adam Max lacked authority at the time he signed that purchase order to do so. Even assuming that that's true, their claim should be for rescission of the purchase order. And Judge Singh, in your opinion in Reef, you made very clear that a conversion and replevin claim requires that there be possession against the plaintiff's right. If there's a voluntary relinquishment, that's not a conversion claim. That's a breach of contract claim. They may have a remedy for rescission. We don't believe they do because we believe Adam Max had authority and that Section 909 of BCL doesn't apply here because it's not a sale of all or substantially all of their assets. They continue in business. That's the test. It's a sale of all their assets if the seller is no longer in business. ALP continues in business. It alleges in its complaint in paragraph 57 that it's remained in business. So 909 doesn't apply. Adam Max had authority, but even assuming, Your Honors, that Adam Max lacked authority at the time that invoice was signed, the remedy should be rescission, and they cannot bring a conversion claim, which is what they're doing. Think about it. While Libra Max, after she became the president of ALP, she accepted $7.5 million, the second half of the payment for this artwork, which they've never returned. They are still in possession of the full purchase price for the artwork. So there's no conversion claim where, in this case, under the facts, as they have alleged them in the complaint, there was an invoice signed by the then president, there was delivery of the artwork both before and after Libra became president, and there was full payment, half of which was made while Adam was president, and the other half of which was made while Libra was president, and she accepted it.
Wasn't there a claim I read somewhere that not all the artwork that was supposed to be delivered was actually delivered, and so they're holding back some? I mean, there's some issues about that.
There was a de minimis shorting of around 2,000 pieces from the 23,000. That doesn't affect the authority of Adam Max to have entered into the
I
invoice
understand,
at the
but
time he
there
did.
is a claim, and so that there may be, I mean, 2,000 pieces of artwork sounds like a lot to me, doesn't sound so de minimis.
Well, but for the record, and this is Exhibit 13 in the complaint, there were 93,000 keepers. There were 93,000 keepers. So in the scheme of things, no, 2,000 isn't very significant. In fact, there was an offer to sell all those keepers, and this is alleged in the complaint, to Park West, which Park West declined, and the invoice that was signed was for 23,000 keepers.
Counsel, is there a negative inference to be drawn against your client that this was a departure from the normal volume of pieces that were sold by Alp through Park West?
No, for two reasons, Judge. Number one is the volume was enormous under any circumstance. They allege in their complaint it was $2 million a month, hundreds of millions of dollars over the life of the relationship. That's number one. Number two is the test is, in terms of, is it an extraordinary transaction, is what is the business of the seller? For instance, had Alp come to Park West, Adamax really wanted to strip the company of its assets and say, we own this warehouse in Lyndhurst, we'll sell you that warehouse. Alp was not in the business of selling warehouses. The test for this court, and this is clear under the cases, including the McPherson case, which we cite, the Providence College case, is what is the nature of the business of the entity? The nature of Alp is to sell artwork, and it sold artwork to Park West. That's a relationship that the parties have had, which the complaint alleges, since 1970. And
These
Park
were,
West has been a huge buyer, huge
Counsel, let me
volume
finish.
of Alp artwork. Sorry.
Yeah, don't interrupt the judge. It's a good rule of thumb for oral argument. This collection of art was Peter's Keepers, correct? Which was apparently the creme de la creme of his work. And so does that make any difference at all?
It doesn't make a difference for two reasons. Number one is it's just artwork, and that's alleged in the complaint, paragraph 146.
There's what, it's what artwork? What'd you say?
It's Max artwork. It's Max artwork produced by a studio, and in the normal, I see I'm out of time. May I complete my answer to the question?
Please answer the question, yes.
Yes,
please.
thank you. In the normal course of things, the artist has some artist proofs that are set aside, and here, it was huge volumes. As they allege in the complaint, they attached the exhibit, 93,000 keepers. And in the past, and this is paragraph 146 of the complaint, Alp had conveyed keepers to Park West. There wasn't anything particularly special about it.
What kind of numbers?
In smaller numbers, but the
Much smaller numbers?
much smaller numbers, Your Honor. They allege in their complaint, which we're accepting as true, 300, but the touchstone issue for the court, and this is the Providence College cases, what was the nature of the relationship and what was the business of Alp vis-a-vis Park West? The business of Alp vis-a-vis Park West was to sell artwork to Park West.
And I do apologize, I just want to continue that thought. Is it accurate that the claim is essentially that you got it for pennies on the dollar? Is that something that we should consider as well?
No. There was consideration as a matter of law, $15 million, and they allege in the complaint.
But if the artwork is worth, I'm forgetting the numbers, $150 to $250 million, or whatever the number is, a much higher number, doesn't that play into that calculus?
No, for two reasons. Number one is they're talking about the retail value, and it's paragraph 81 of the complaint. I urge the court to consider it. They make clear there the pricing for these keepers was very close to what Alp always sold artwork to Park West. Park West always purchased artwork from Alp at a 10% discount over its normal wholesale pricing. Here, it was a 20% discount. It's very close.
And there was a claim that these were the special things, the Peter's Keepers. So you got a double discount on things that were considered the special work. So hand in hand, it's a big difference.
There are allegations to that effect?
Yes, I understand, but again, we both say it's a 32-11 motion on a very complex scenario, and it's hard to say, okay, everything should be dismissed at this point. I mean,
Your Honor, I hear you. If they can travel at all, it's under a rescission theory, not a conversion theory, because it's not a conversion where they voluntarily ship the artwork. They received and have retained the consideration that they agreed to, signed by their president at the time. Thank you so much for your time, and I'm sorry.
Thank you very much. Who's next?
May it please the court, Daniel Green of Vetter Price for appellants Bender Siccato, Robert Frank Sr., and Robert Frank Jr., who were Bender Siccato employees. Bender Siccato is an accounting firm that provided business consulting services to Alp over a period of 7 years. Those services were provided pursuant to an engagement agreement that contained an arbitration clause requiring any disputes over fees to be submitted
And
to
you're,
arbitration.
okay. Now, Judge Bannon discussed this in her very lengthy decision, where she discussed everything. To say this was just fees, the allegations here are much, much more significant than just, oh, you should have charged me $100 an hour, and you charged me $200 an hour. They're claiming sometimes you're doing thousands and thousands of dollars an hour, that these were not just fees, you were taking commissions, you're doing all kinds of unauthorized work way above and beyond what the accountant should be doing.
Your Honor, we were not engaged to provide accounting services. We were providing business consulting services. And I don't think there is, or I'm confident, there's no allegation that we were paid on a commission basis. We were paid on an hourly basis. And
as much as, I think, $2,000 an hour at times, is that right?
I know what the court is referring to. There was a brief period where there was an issue with my client's billing software. They've acknowledged that error and I believe issued ALP a credit for that amount. But in any event, they're still owed a substantial amount of money by ALP, and the amount that they're still owed significantly exceeds the credit that's associated with that brief period of overbilling. But we really are talking about a period of only
So let's go back to the arbitration. Is this a narrow, or in your view, a narrow or broad arbitration provision?
It is limited to disputes over fees.
So who decides arbitrability under those circumstances, the court or the arbitrator, where it's a narrow fee as you concede?
I believe in the context of a narrow fee agreement, it's for the court to determine.
Okay.
And in this kind of case, we would look to see whether or not the claims that you are seeking to, the claims the plaintiff is seeking against you are inextricably interwoven with the other claims. And given the many, many claims, maybe they'll all be proven wrong, but right now we're at a 30-11 motion. You're going to take this little piece to arbitration and not be part of this lawsuit?
I don't think it's just a little piece, Your Honor. The only way in which my client is alleged to have benefited from this nebulously defined conspiracy is through the payment of its
But that's not
$13
true.
million
I read allegations that Frank Jr. had a fake job, a no-show type of job, to stand over at the warehouse in New Jersey, wherever it was, to make sure that all the artwork was going where it was, and part of the alleged conspiracy of the Gang of Five, as the plaintiff calls it. So I don't see that that's just fees.
Your Honor, fundamentally, the issue that plaintiffs take with Frank Jr.'s role is in the fees that were billed by him. He was stationed at the warehouse in order to oversee Hurricane Sandy remediation efforts, but the allegation is
which
not...
was questionable also, based on what I read in
The allegation is not that somehow undue influence was exercised that resulted in him being hired by ALP. He was a Bender-Staccato employee, and ALP takes issues with the fees that were generated as a result.
So again, the red light's on, and I apologize. Is it your view that the claims...
You're allowed to ask questions.
Your claims can't be separated into fee claims, non-fee claims go to arbitration, non-fee claims stay in court. Is that your position, that they have to be considered together at all times?
I do not believe that the claims against my client are inextricably intertwined with whatever else is there. As you've already heard, my client is quite differently situated from the other parties, and what's not a fee claim against my client really boils down to the Peters Keepers sale once you cut away the conclusory allegations and the impermissible group pleading. And I don't know if the court is aware, it's reflected in the record, though, that sale has been enjoined. So ultimately, there will be a resolution to it that will not really contemplate damages collectible from third parties. So I don't think that the court needs to so finely parse the claims asserted against my client. I think the court can, on this record, determine that the claims against my client are not inextricably intertwined with what's asserted against the remaining two defendants.
Okay, thank you. You'll have a minute or so for rebuttal. Okay.
Good afternoon, Your Honors. May I please the court? My name is Jolene Levine Albert, and I'll be arguing for Respondent Alp Inc. I intended to take in order the accounting appellant's appeal, followed by Park West and Lund's, unless the court would wish to direct me otherwise.
You start how you want to, and we'll ask what we want to. So
Sounds great. Thank you. With regard to the accounting appellants, the motion court denied in its entirety the motion to compel arbitration. It seems Your Honors have read and, of course, are very familiar with the record. This arbitration clause was extremely narrow. Not only that, but the engagement letter itself that was signed in May of 2012 provided explicitly that some disputes would be litigated, and a very narrow group of disputes would go to arbitration, and that was dispute about fees. This, only by ignoring the complaint in its entirety, could anyone conclude that this was a dispute about fees. In addition to the items that Your Honors have already raised, there are allegations in the complaint that Robert Frank, the principal of Bender Chicado, was of course de facto officer of ALP, but also that he threatened Libra Max, he refused to give her information about the company for which he was an officer, director, and shareholder. He forced himself into a board meeting where he spoke instead of Adam Max. He placed his son in the warehouse. There is so much more here than fees. And of course, if we look only at the invoices by Bender Chicado, those were not a dispute on fees. These invoices were fraudulent. So there's nothing here that would have to be arbitrated.
Counsel, just so I'm clear, maybe you were just getting to that. Is it your position that none of your claims in your complaint as against the Bender defendants are subject to arbitration?
Absolutely, 100%.
And that's because you say it's not really over fees? Because they're fraudulent invoices, or what?
Correct, because there are fraudulent invoices and because there was so much additional misconduct by the accounting appellants that cannot be extricated from the rest of
they're inextricably intertwined.
Correct.
To the extent there are some claims that they can call fees, they all they're in a larger scope of situation.
That is correct, and there's additional reasons why we think that this should not go to arbitration at all, which is the fact that this dispute, as we allege, is not within the subject matter of the engagement letter that was signed in May 2012, which is the only agreement that contains an arbitration clause. That engagement was very narrow in and of itself. It provided that Bender Chicado would answer questions that ALP would ask, and it provided that to the extent the services would be expanded, there will have to be an additional engagement, which there never was. This was May of 2012. Robert Frank himself has stated in sworn statements to courts that the work that Bender Chicado and Frank did was incredibly broad as it could be. It was not accounting work, and that a lot of it had to do with insurance work arising out of Hurricane Sandy, which of course did not occur until October of 2012, 5 months after the engagement letter had been signed.
Counsel, what do you say about the argument that the allegations are insufficient for the heightened specificity requirements of CPLR 3016?
I would say to that this complaint, as I'm sure the court has read it, is incredibly long and very specific. As I said, the allegations against Robert Frank, Frank Jr., and Bender Chicado include not only that their invoices were essentially fraudulent, but also that they took control of the company, that they unduly influenced Adam Max, that they made him they wrote for him and made him sign documents that stated that Moskowitz should get such sum of money. They held the books and records of ALP outside of ALP, but they control the money, they control the company. The allegations are incredibly specific.
Would you address the fraud allegations against Luntz?
The fraud allegations against Luntz. Sure. So Luntz is alleged to have taken, first small thing, and then I'll get directly to your question, Your Honor. Luntz's appeal is in large part academic because he doesn't dispute that ALP hasn't sufficiently alleged misconduct with regard to the keeper's transaction. So even if Your Honors were to accept everything that Luntz argues on this appeal, all of the claims can be maintained with regard to the keeper's transaction. In terms of the fraud claims, so what ALP alleges is that Luntz took commission, 15% commission on every transaction, essentially on every sale.
Do you allege fraud with respect to the commissions?
We do allege fraud.
In your complaint?
In
the complaint, you allege fraud?
We do allege fraud against every defendant.
With respect to the commissions, specifically with respect to the
With respect to the commission, because Luntz was a fiduciary, which we allege at length. And there are, what we allege that each time he took a commission, a 15% commission, he, as a fiduciary, had an obligation not to lie to ALP, essentially, and he would lie to ALP by requesting the 15% commission, representing to ALP that he worked for this commission, that this was not just a no-show job, which, ALP would not.
Well, he says that he had a very long-standing relationship with Park West. You claim that Mr. Max had a very long-standing relationship with Park West. Maybe they both did, and that would make sense to me also, but, and he was taking the 15% commission for that?
Well,
access to Park West for?
Sure. A few things to that, Your Honor. First, on this motion, what we say prevails, and so that's answer number one. Peter Max did have a longstanding relationship with Albert Scaglione, who is the CEO of Park West. What we allege is that Luntz did not do anything for these sales. ALP employees handled the shipment, the orders, everything. Luntz just sat there and collected the 15%.
So it's a failure to disclose, right?
It's a failure to disclose.
And so, okay, so then what's the factual predicate for the failure to disclose?
The fact that every time he asked for his 15% commission, he failed to disclose that he had done no work for this transaction and that the transaction was actually detrimental to ALP because he made Park West a competitor to ALP. He gave Park West prices that undercut ALP, that diluted the value of Peter Max art, and that was actually detrimental to ALP. He could not do that. He was a fiduciary duty. His loyalty was supposed to be to ALP. He failed to disclose that he did no work for the transaction, and the transactions were actually detrimental to ALP.
You have to get a question, at least one question with respect to each group of defendants. Here's the question for Park West.
Sure.
How do you respond to the argument that your remedy, if you have one against Park West, is one in rescission?
We're saying that this is not a breach of contract case at all. We're not saying that Park West, did not pay us enough money. We're saying that these artworks were not for sale. They were pieces that Peter Max himself, the founder and the artist here, had said, these are not to be sold. He had said, those are the ones I preferred. They are to be kept for my children. They're not to be sold.
Yet the money that was received, you kept.
We have kept the money because we claim that this artwork was worth $400 million. And we're claiming punitive damages, of course, prejudgment interest on joint and several liability basis costs. And so, my opinion, Your Honor, is that that fact, first of all, is not relevant, essentially, to this motion. There's nothing else. Thank you, Your Honors.
Okay, thank you.
Very briefly, Your Honors, I'd make 3 points for Gene Luntz and Gene Luntz Management. First, there is no fraud claim here. There's no misrepresentation or material omission.
It's a non-disclosure, counsel, so why don't you address the non-disclosure?
It's a non-disclosure case. ALP knew what ALP was paying Gene Luntz for. ALP made its own decisions to pay Gene Luntz. It had all of the facts at hand.
But doesn't that,
and all of them,
I'm sorry to interrupt, doesn't that, again, then go to the undue influence? Isn't linked to that, if in fact?
Absolutely, Your Honor. I think, the case does begin as an undue influence case. That's what the court
So if we were to find that it's sufficient for undue influence, are you suggesting that the other claims stay then, right?
Well, I don't think the fraud claim stays for other reasons as well, including reasonable reliance. I don't think that, ALP itself could reasonably rely when it had all the facts at its disposal.
But they had a long-term relationship with Luntz. He was supposed to be, we're talking about Luntz, right?
Yes, ma'am.
Yeah, who was the art dealer, right? I mean, he was supposed to be advising him and dealing with his art, so why wouldn't he be relying on you to make good decisions about the sale of the artwork?
Well, I think he would.
Why would that not make sense?
I think he would, and in fact, Mr. Luntz did make good decisions, and it made tens or hundreds of millions of dollars for the Max family.
Yeah, that's great, except if there were, if, as they claim, the paintings are worth 5 or 10 times more, then it isn't really a very good deal. Then they should have been making much more money for them.
Well, the prices themselves, maybe it's beyond the complaint, were set by Peter Max himself, and that's what the facts are going to show.
After 2012, when he now has a guardian?
The prices didn't change after 2012. Peter Max set the prices, and essentially the prices stayed the same. But going to the undue influence, I do think it's critical to see that over that period, 2012 to 2018, there's not a single allegation specifying undue influence or Mr. Luntz's exercise of undue influence over Adam Max to get a commission or to make a sale or to get approval for anything. That doesn't meet the requirements of 3016 to specify the allegations of undue influence. And if I may just say one more thing and have one extra second, as we address in our briefs, the aiding and abetting claims and the conspiracy claims don't make it here. They don't make it because there's no allegations that Mr. Luntz gave substantial assistance in any way to any of the litany of charges of wrongdoing that the complaints, the Moskowitz complaint in particular, makes with respect to the Mr. Moskowitz, Mr. Frank, and Mr. Frank's businesses. Thank you. Appreciate it, unless you have questions.
Next.
Yes, very briefly. Here is the course holding in the Reef case, which Judge Singh authored. Where a party's interests have been sold, there can be no interference and a conversion claim may not be maintained. The court continued that a voluntary relinquishment of property is not a conversion. And attached to the complaint is an invoice signed by the then president of ALP.
I understand that, but the allegation we said is that there was undue influence on Adam to enter into these agreements and to sign that. So even though you keep telling me that there's, and I know that there is, that he signed it, that's not the end all or be all of this story.
Their claim is that he lacked authority to sign
That's
it.
right.
We recognize that, but that is not a $400 million conversion claim as against Park West, and here's why. Park West wasn't the fiduciary of ALP. Park West's obligation was not to maximize the amount that it was going to pay to ALP for artwork. Its duty to its shareholders was to minimize the amount that it was supposed to pay because it's an arm's length buyer. Understand, Mr. Luntz was the agent of ALP working as its brokers. He had separate duties. Our duties were to our shareholders to minimize how much we paid. And the idea that this was rushed and all that, it's no different than the car dealer saying, hey, the manager's going to show up and this deal won't be available tomorrow.
Yeah,
you better
well,
do it tonight.
I somehow think it's a little different, but okay. Judge Higgett, did you want to ask a question? Oh. Okay, go ahead.
Thank you so much.
Okay, thank you. Okay, counsel, anything else?
Yes, one minor point on the question of whether the claims against my clients are inextricably intertwined with the other claims in the action. Whatever argument there might once have been in support of that position is largely gone now, and the reason for that is that there was once a similarly situated defendant, also previously an appellant in this matter, Lawrence Moskowitz.
Yeah, he settled.
He is gone now, and so what's left are the claims against ALP's longtime sales agent and ALP's longtime dealer, both of whose involvement with ALP greatly preceded my client's entry onto the scene in 2012, and which are genuinely discrete from the claims against my client. So if the court doesn't believe that it can refer the matter to arbitration, it could nonetheless remand to Justice Bannon for further consideration in light of the settlement of the claims of Mr. Moskowitz and his withdrawal from the case. Thank you.
Okay. Am I done? Did we finish? I gave everybody the rebuttal? Okay.
We're done.
Thank you very much. Your argument's very interesting.